and Legal Studies organized at our faculty. And let me say that we are deeply honored that you have accepted our invitation and all of you are willing to give us very interesting papers. We are looking forward tremendously to all your papers, and we do not lose the hope that sooner or later we will have the chance to meet in person, not in this hybrid online form. The chairman of the first session is my learned and esteemed colleague, Professor Michał Balcerzak, to whom hereby I pass the word. Professor, the floor is yours. Thank you very much.
Thank you very much, Professor Jońca. It's a great honor to well, serve you in the capacity as chairperson of this panel, and welcome. As Professor Jońca said, it's the fourth panel of this very interesting conference, which is dedicated to the memory of Professor Chipita, and it is on the understanding of law and legal studies. We have three panelists today, because I was informed that unfortunately Professor Guastini will not be able to be with us this afternoon almost. But nevertheless, I think that we would try to, well, accommodate that, because we could have a bit more time for discussion later on. Each of the panelists was allocated with 20 minutes of time, and I would very much and kindly ask the panelists to keep this time discipline. But obviously, the essence of every panel and every conference is discussion as well. So I will do my best in my capacity to save as much time as we can for exchange of views and comments, questions to the panelists. So again, welcome. Without further ado, I would suggest that we would move forward, and I would kindly invite our first speaker, Professor Anne Wagner from Lille University, Lille, France. Professor Wagner's theme today is the doctrine of flex law within the field of jurislinguistics. I very much would like to invite you, Professor, to take the floor now. Vous avez la parole, madame. Make sure that your microphone is unmuted.
Okay, do you hear me now?
Yes.
Okay, thank you for having invited me. I will discuss today about the doctrine of flex law, which is part of a research project that I've been carrying for almost 10 years right now. So I have extracted some key issues about it from two research handbooks that I am preparing for Edouard Elgarde. One is on the research handbook on jurilinguistics, and the other is on legal semiotics. So I will discuss about the aspect, the legal and linguistic aspects of the doctrine of flex law and how we should deal with it. So what we could say first is that the language of the law opens the way to an alternative method of exploration, which is defined as flex law. It is an approach that articulates semiotic logic with the development of specific analyses in order to promote a rather unstable interaction. The available space may be not fully delimited. It could either be imperfectly identified or partially circumvented. Alternatively, this space leads to many questions in terms of legal and linguistic analysis when dealing with legal interpretation in specific case reports or even legislation, from one space to another, from one country to another country. So what we could say is that social identity may seem incomplete or unclear when dealing with this aspect of the doctrine of flex law, but still the language of the law may be understood in very distinct temporal spaces. This deliberate lack of real boundaries that I also titled The Silent Otherness in Law allows legal language to stand apart from others, leaving a crucial role for legal interpretation, that is the doctrine of flex law. Why did I decide to look at the jurilinguistic aspect, and why did I'm talking about jurilinguistics? Jurilinguistics is first a concept that was extracted from Canada, that comes from Canada, because Canada is a bilingual and bijuridical country with co-drafting techniques, and it has been developed by Jean-Claude Guimard, who is at the origin of this movement of jurilinguistics. But if we look at jurilinguistics in other countries, like the European countries, we do not talk about jurilinguistics, but mainly we talk about legal linguistics or legilinguistics. And this analysis of legal language is based on its flexibility. That's why we are talking about flex law. So the interpretation of law is common because of its main sources. We could have usage, custom, case law, jurisprudence. Rules-inclusive theories in a concept of legal vagueness are decisive in law, but their use requires some precaution since their interpretation is intricately linked to social conception and rational processes in force in the countries under investigation. So flexibility in gender, flexibility in meaning, flexibility in time and space exposes the very identity of a specific linguistic community, namely jurilinguists, or what we say in the European Union, we talk about lawyer linguists. So this flexibility is a mode of productions that enables an understanding of the social and historical context in motion in this third space of law, in this space of interpretation. Every discourse is a customized construct where issues, protocols of experience and procedures reflect legal reasoning. The law differs from other texts in that it takes its linguistic roots within a relevant national language. The aim of the law is to clarify terms and forms. At times, it distorts them, possibly even changes the initial intention behind these terms, concepts, and all notions. The outcome is a structure that is specifically tailored to the intended goal, specifically to establish a unique place in the midst of confusions and obscurities, what we call legilinguistic, legal linguistic, or jurilinguistics. So legal language permeates with meanings found in ordinary language in an attempt to try and rigidify semantic constructs that include random factors. This appropriation creates tension that can be observed in both speech and writing practices. The language of the law from one country to another, from European to international institutions, formulates relations that are maintained in an artificial microcosm. So this microcosm is both the essence of power and its result. It is organized around a theoretical legal entity, namely the states, whose permanency lies in the power it assumes over and for its citizens. Its value also equally depends on its regenerative ability by means of appropriate words or even visual signs, the meanings of which tend to be more or less clear-cut, thereby generating a degree of flexibility in its application. So this flexibility is paradoxically rigid in its implementation. Such malleability, also named by Brockman or Caleb Baker, fracture, fluidity, permeability, enables users to adjust their meanings to specific and contextualized situation. Yet the origin of such an approach stems from the evolving nature of society, what François Génie called at his time the living reality when he wrote his different volumes on it in 1922, and what also Jeremy Bentham talked about, this living monster that keeps evolving within time and space and can modify its initial meaning in a specific context and circumstance. So this approach is based on this evolving nature of language, which is a medium of thought, and it is also built by the sedimentation of several cultures due to its historical and societal constructions over time and space. So these historical and social influences create a complex combination that is embedded in the mindset of practitioners of the law, thereby generating a rather uneven legal dynamic. Users have to interpret the meaning provided by the law under the influences of space and time. This dissociation between the meaning provided by the law under the influences of law, space and time is further amplified through what I call mediation, what we could call legal interpretation. So the changes in the rules of language, coupled with the development in the modes of expression, constitute a source of regeneration of the law. Codes like syntax, morphology, semiotics, semantics, and even stylistics constantly rearrange their connection to legal linguistics, legilinguistics, or jurilinguistics. This code that Fish talked about is an entirely flexible instrument for organizing contingent experience in a way that does not preclude but renders inevitable in its own modification. So flex law enables adjustment to practice with words, concepts, or notions that remain variables of adjustment. These variables consist in malleable application that open up the possibility of reorganization in a variety of time spaces. Jean-Claude Gemard and I wrote an edited volume with Semiotica over these issues of jurilinguistics and their modification over time and space. And we made the point that law presents a stunning textual diversity, since there is not one language of the law, but an imposing array of legal language and forms depending on who and what is authoring and on the subject and matter at stake. This reflects modern society's mind-boggling heterogeneity and its trail of activity engaging law. So accordingly, this establishing a fairly open framework of exchange, neutralizing the influence of a specific context, shapes new possibilities of understanding and a flexible combination of freedom in meaning. And I'm going to introduce a concept raised by Benveniste, who is a French linguist. He talked about the concept of vanishing event. And when he talked about the concept of vanishing event, he said that it is one of the primary features of any sentence, meaning can only be validated by its inclusion in a context which integrates its semantic logic into a specific space and time framework. It also goes with the idea developed by Judith Butler at her time, when she says, and I'm just quoting her, the writer is blind to the future of the language in which he or she writes. Thus, language is thought of mostly agency, unquote. So therefore, The doctrine of flex law is highlighted by the many possibilities given to multiple interpretation, and so to be properly grasped within a specific period of time, flexibility will eventually turn inflexible over a specific moment of time. So flex law doctrine expands the field of possibilities and challenges the limits of interpretation and understanding, which is a daily challenge for jurilinguists, lawyer linguists, legal academics, legal theoreticians, legal semioticians, and even legal translators, both in the European or international institutions. Nevertheless, we ought to bear in mind behind each term, concept, and or notion are dissimulated, diverse, fluctuating, soft, fragmented ideas, so that only an interpretation at one moment in time will assign a meaning to them that reflect the motives, the aims, and the interests that are supposed to belong to the transmitter of the message at that specific period of time. So the point that I'm making is that we need to preserve a space of meaning where the internal lines of actions are flexible enough to fit into the current environment of intelligibility of the message. So the doctrine of flex law constitutes a break point between the established reality and the reality to be constructed, and acts also as a prism that allows us to see past and future realities, although this vision is never complete. François Oster talked about the contours of this temporality in various layers when he talked about the time of the foundation, timeless time of the legal dogma, the time of the instantaneous, the time of the long duration, the Promethean time. And I won't go into further details, otherwise I would exceed my time to talk. So flex law relates also to the theory of open texture that was developed by Art, where he states, and I'm quoting, "There must be a core settled meaning, but there will be as well a penumbra of debatable cases in which words are neither obviously applicable nor obviously ruled out." And again, this idea of flexibility, Sarah Marusek from Prawa University and I developed it in an edited volume with Frank Flierakers from Leuven University. And we talked about this idea of flexibility, and we compared it to an integrated circuit with two main lines of developments, at times autonomous, at others conflicting with each other to reveal a new vision of reality. So this integrated circuit thereby enables the law to grow with the life surrounding it, while simultaneously reviving concepts sometimes far too deeply rooted in a predetermined time period. Yet the law as a living organism has the ability, and I'm referring to Deleuze and Guattari, the law as a living organism has the ability to territorialize a concept while also creating alternative trajectories or deterritorialization routes for more modern and contemporary visions. In this way, this two-stage integrated circuit may be a source of either promise or struggle in addressing and understanding new visions of the law. So we need to speak about these lines of resistance that were also developed by Deleuze and Guattari. And these lines of resistance are in fact refusal, hindrances of evolution or adaptation, as well as other lines the lines of transformation that are considered as acceptance of an evolving world with new conception of the past living reality. And this is something we've been talking about with Sarah when we talked about the evolution of the concept of ecocide that was originally coined with the Vietnam War and the Agent Orange. And as from 2010, it has changed and is more like the destruction of the whole environment without taking into account nowadays the chemical that was used during the Vietnam War. So this is just to give you a basic example of it. So as a result, what we could say is that the doctrine of flex law remains fragmentary and allows for certain dynamic in the language of the law. And this is really important because this is what we are doing all the time when we are looking at legislations, regulations, or even case law from a different period of time. We have to analyze them in a specific context. And if need be, we need to transplant them into a modern vision. And maybe we also need to adapt them to the new situation. That's why we are talking, and that's why Jeremy Bentham is talking about a living monster. That's why Deleuze and Guattari are talking about the rhizome theory, these roots that keeps expanding everywhere, cutting themselves, reorganizing themselves in other trajectories in order to fit new living realities. Thank you for your attention. I think I've been brief.
Thank you very much, Professor Wagner, and also for this excellent, let's say, keeping the time discipline. I think we were all listening with great attention, and to be honest, I cannot wait until the discussion phase. I would have some questions myself, but obviously I will restrict myself at this particular moment. That's extremely interesting, the doctrine of flex law that you were like trying to make closer to us, and I'm sure that we will have time at the end of the panel also to exchange some views about it. So thank you very much. Merci beaucoup. And now I would like to invite our next speaker. It will be Professor Jean-François Kervegan from University of Paris 1, Panthéon-Sorbonne. Professor Kervegan Professor Kervegan's paper or presentation would be about an institutional ontology of rights, some proposals. I invite Professor Kervegan to take the floor. Make sure that you have unmuted your phone. I don't, perhaps it, there is this option in Zoom on the left bottom left corner. Yes, you have unmuted your microphone. I cannot hear you. I don't know how other participants, but I suppose that, okay, just a second. We'll get that.
No?
Yes, now we can hear you, Professor.
There is a problem with, with my, okay. Thank you, Mr. President, for your kind invitation. I will quickly sketch a question I am currently considering, namely the institutional approach of rights due a peculiar philosophical conception of what an institution is. So I speak as a philosopher that I am. My reading of Hegel's philosophy of law led me to the conclusion that an institutional perspective might offer a promising framework for a conception of rights that tries to escape the alternative between natural law theory and legal positivism. From the viewpoint of natural law, rights derive from the very nature of humanity. natural, inalienable, and sacred, as the French Declaration states, rights are the norm for assessing the actions of the constituted powers because they define, I quote, the purpose of any political institution. Quotation from the French Declaration from 1789. From a positivist viewpoint, by contrast, the only real rights are created by positive law. Right is the son of the law, as Bentham says. Therefore, the idea of rights that are not created by human acts is a nonsense. Such rights are quite simply imaginary, Bentham says. Objections to these two conceptions are well known. Rights derived from a now unclear nature are at risk of being ineffective. The assertion of natural rights is an expression of a respectable claim, but, as Bentham says, I quote, reasons for wishing there were such things as rights are not rights. Hunger is not bread, end of quote. Conversely, aren't rights from solely positive source, legislation, customs, or case law, vulnerable? The intangible character of the basic rights of the human person seems to be inconsistent with the unstable status of positivity. To put it in Kelsen's terms, if the existence of basic rights is a pure rational requirement, their effectiveness, Wirksamkeit, presupposes an external guarantee that is always insecure. In contrary, if these rights are purely positive, their validity, Geltung, remains relative. How could an institutional perspective contribute to a restatement of the definition of rights? Those conceiving of rights as institutional facts provide a third way between the demonetized view of natural human rights and the subordination of rights to the uncertainties of positivity. Sorry. Okay. Although institutionalist theories of law did not always take the question of rights as their main focus, they incite us to understand rights neither as natural and imprescriptible rights, natural law perspective, nor as mere creations of a sovereign fiat, positivist perspective. Rather, they should be seen as institutional facts. As Neil McCormick writes, I quote, "It is by an interpretation of our given situation against an assumed background of institutional normative order that we can consider ourselves to have various particular rights," end of quote. We are led to give up the vision of rights as normative attributes attached by nature or by convention to individuals or to certain classes of individuals by considering the fact that rights are only meaningful within a network of institutional settings that constitutes, for individuals and social groups, a second nature, as Hegel said. This understanding of rights may also provide a more convincing description of the nature of collective rights or even of rights without human holders than those that remain tainted by an individualistic bias. Savigny, in the 19th century, points out that institutions called Rechtsinstitute are always presupposed by any legal relationship and any ascription of rights. This does not mean that these institutions would exist forever, but that their network and the possibilities and impossibilities that they define must be considered in assessing a situation normatively. Rights, including the most basic ones, should not be seen as invariant properties of individual or collective subjects, which are given once and for all, but rather as linked variables within a more or less formalized set of legal institutions. Rights are, as the philosopher Jońca says, deontic powers attributed by acts of collective intentionality. But the nature and scope of these powers, as well as the forms of their use, are closely linked to the context in which they are defined. It is clear, for example, that the definition of personal rights depends on the way in which personality is understood, depending on whether or not it is linked to statutory preconditions, as in Roman law, or on whether or not this right is ascribed solely to human individuals. The powers allocated to it, as well as the constraints that this implies, can be highly variable. Let's take an example, that of contractual sale. This legal act entails a series of conditions and consequences. In their detail, both belong to positive contract law, but the institution contract itself is presupposed as a fortiori the institution without which contract is meaningless property. It is true that forms of property and figures of contract have significantly varied, but as the French jurist Maurice Oriou says, the leading idea of these institutions logically precede all provisions, rights, duties, liabilities that concern contractual relations. These provisions are only operative within the framework of institutions, or more often, of a network or system of pre-existing institutions, which defines the horizon of what is legally conceivable and practicable. The institutionality of basic legal concepts, not to be confused with their institutionalization, which is always precarious, is what preserves law and rights from the fragility implied by the positiveness. It protects them to a certain extent from against what a conservative scholar like Portalis, the main author of the French Civil Code, called the revolutionary mind, l'esprit révolutionnaire. However, institutions are not immune to change, as shown by the developments in case law and the phenomenon of the defeasibility of legal rules. Provisions of positive law, including those relating to basic rights, are always open to revision, as demonstrated by the changes in the list of such rights in the successive declarations. These revisions do not only reflect the discretionary power of the constituent, the legislator, the court, or the public mind. They also satisfy an internal requirement for normative consistency. If interpreted in institutional terms, this requirement means that the provisions of positive law relating to the same subject matter, for example, say, must derive consistently from the same idea of the legal institution, for example, contract, within of the legal institution within which this subject matter should have certain legal meaning and consequences. This is why positive law sometimes puts in order the provisions concerning this topic or the field to which it belongs. We might ask whether there are any determinations, and in particular rights, that are inherent to the net of legal institutions and so relatively immutable. The first step in addressing this question is a historical and comparative examination. For example, can we plausibly infer the existence of non-trivial invariants from the known examples of the institution property or contract? It seems obvious that the meaning of these institutions has deeply changed since the recognition of everyone as a legal subject. Henceforth, no more dominium utile or dominium eminens, as in feudal law, even if some traces of its theological and feudal origin remain in the post-revolutionary concept of property. This paradigm shift has obviously profoundly modified the conception of rights regarding the institution of property and also of rights in general. We can try to go one step further. If it becomes clear that the institution of property, that of the proper which an individual or group must possess or gain in order to acquire a legal identity, involves invariant features, among which are lawful claims, rights. It will be, in that case, it will be appropriate to provide them with a kind of ontological stability. This is what the natural law theories were doing with their own tools. Hobbes, with the idea of everyone's power to preserve his own nature. Locke, with the idea of the individual's property as a result of the labor of his body and the works of his hands. Kant, with the idea of everyone's innate right to legal personality, etc. It seems to me that the idea of an institutional constraint, if one understands by this the requirements involved in the very idea of a legal institution such as property or contract, can be a good alternative to these onerous assumptions. Indeed, it is exempt from the requirements to ground legal matters in a higher order reality whose analysis is anchored in a philosophical anthropology or a metaphysics. By institutional constraint, I mean that the conceptual, not the factual arrangement of an institutional system, its guiding idea in Orius' sense, determines the scope of the possible actions within that system, as well as the norms governing these actions, which define the rights and duties of each agent. Consider an example. In his Theory of Constitution from year 1928, Carl Schmitt writes that, I quote, a majority decision of the British Parliament would not be sufficient to turn Great Britain into a Soviet state, end of quote. It means, in my opinion, that the institutional system of parliamentary democracy includes constraints, legal and extra-legal, political, ideological, which exclude such a possibility, even if it is formally open. Even under a Rawlsian veil of ignorance, British legislators, simply because they are acting in the context of an institution, could not reach a decision that would involve a performative contradiction. If we generalize this insight that legal institutions involve conceptual constraints related to their idea or concept, we are led to understand rights as linked variables within patterns that determine their variations. Understood in institutional terms, rights are not tools for free legal subjects and their interests, but relatively unavailable parameters for their action, which of course has an impact on what it means to have a right. To conclude, rights, at least the most basic ones, that is, those that are intrinsically linked to an institution belonging to the basic lexicon and grammar of law, are neither purely positive nor belong to a timeless rationality that were part of man's reasonable and social nature, as Grotius said. Rather, they are part of an institutional objective rationality, developing and transforming itself in the long term and nourishing evolutionary social practices. In short, the investigation of the normative order within which rights are embedded consists, as the French philosopher Vincent de Combes puts it, in examining, I quote, how such an order can assume the character of an objective spirit in Hegel's sense of the term. Thank you for your attention.
Thank you very much, Professor Kervegan, also for keeping the time. Let me just share a thought with you and all the participants. I suspected this panel will be interesting, but I didn't know it would be that interesting. Professor, you started with Bentham, you ended with Hugo Grotius and Hegel. That was indeed enlightening. And also, let's say, make a small coming out here. I am a human rights scholar by profession. And the question of ontology of rights and ontology of human rights is something that fascinates me. Because in essence, even though I might find an answer to the question whether there is a good reason to have human rights, you may always tell me that this reason is not good enough. I hope that we have chance to exchange views on that later on. Perhaps I'm wrong in telling my students that we are on a post-ontological phase of human rights. I'm very much interested in what you think, because, well, of course, we refer to human dignity, but whether or not it is sufficient, whether it convinces everybody, it's another story. So thank you very much for your presentation, and we still have the discussion phase ahead of us. Now, I would like to warmly welcome and invite our third and final panelist, Professor Angela Condello from University of Messina, Italy. Professor Condello will tell us about legal science between datum and result, contemporary challenges. Professor Condello, you have the floor.
Can you hear me?
Yes, it's just I don't think we can see you.
Yeah, I am trying to activate.
Okay.
Yes. Okay, wait. Yes, it should work now.
Yes,
okay.
Now we can hear you. We can see you. The floor is yours.
Okay, great. Thank you very much, Professor. I'm very honored, I would say, to intervene in this conference, especially after these great scholars. Let me just activate the chronometer so that I'm sure that I will be as precise as the two speakers that preceded me. And so the paper I'm presenting is actually the result of a book that I'm publishing. Is basically forthcoming next month or so. I'm still very much into this research and into this discourse. So the main question that I will address today, because of course I will just focus on one single problem of that larger work on method, which is the main topic of the book, is the following. Is law a science? And if so, what kind of science? So not really the smallest question. This was actually a question that constituted the core of a wide debate. The debate, I'm referring specifically to a debate which was mainly concentrated between the years after World War II and the end of the 60s, and especially I'm thinking of the Italian development of analytic philosophy of law. So the kind of bibliography and authors I will also refer to, mainly Norberto Bobbio and Uberto Scarpelli, are quite specific, and I wanted to make sure that I'm staying and sticking to them, because of course the question of the scientific nature of law is definitely too broad to be addressed, even in much more than 20 minutes, which is the time I have. So the question again, is law a science? I think must be revitalized today, and that's why I'm representing and going back to that question, despite the fact that it can be somehow located historically quite precisely in a period of time which is past, very, very simply, and past. It has been past for some time already, but I think it is particularly relevant today because of one specific event which has occurred in the last decades, and especially in the last years, which is the introduction of artificial intelligence and algorithms in legal professions, so to say, quite broadly. So of programs based on artificial intelligence, which can be used by both lawyers, legal practitioners, and potentially even by judges. So at different levels of the legal institution, to use a term which is very important and which has been thoroughly analyzed by Professor Kervegan. So at that time, in the end of 40s and 50s, and towards the 60s, especially I'm looking at Italy, but then this question spread throughout our analytic jurisprudence, also outside of Italy. The question was quite crucial because the intellectuals, and now I'm thinking not just of philosophers, but also of legal philosophers, but more broadly of philosophers, wanted to establish a so-called new rationalism, and basically were very much focused on epistemological issues, and that's why law and science and the questioning of this association, in reaction to the first phase of that century, which had been characterized by much more metaphysical instances. I'm thinking, especially in Italy, of Croce and Gentile. So, you know, the heritage of idealism, and then the development of phenomenology, and especially of existentialism, which were the main sources of the thought which developed towards the end of the 40s and then in the 50s. But also, these were the roots that they wanted to eradicate. These were the roots they wanted to somehow react against, especially because, in some sense, just I'm cutting a very long story too short, these roots were considered even responsible to some extent of what had happened during the Second World War somehow. And so the reaction was not just an intellectual reaction, but it was actually a political reaction, or the two things were very much interconnected. And legal philosophy was not somehow outside, it was not neutral. to this specific period and to this tendency, and therefore there was also the development of the so-called analytic philosophy of law, with the very famous publication of the especially the article of Norberto Bobbio, Scienza del diritto e analisi del linguaggio, so legal science and language analysis. So basically the core thesis was that if law were to be considered a science, and that was very important because they felt the need to root the law in a sphere which was more scientific and less arbitrary, so less depending just on politics. The linguistic analysis, the so-called analisi del linguaggio, so the attention on how terms are used and how they're contextualized, so the kind of questions that then somehow also Anne Wagner addressed in her paper, were at the core, were put at the very core of the legal philosophical enterprise. Now, I want to claim that in the present era, because of the numérisation, of the digitalization, and I'm using the French term for a specific reason, because of the digitalization of our lives, professions, and mainly legal operations, which are those I'm thinking of more specifically, a relevant shift in the linguistic nature of legal data is going on, or definitely might be going on, but I would say is going on. We can speak with the present tense because these kind of programs are already being used. They are not just a science fictional dimension or project, but they are instead often implemented. Of course, when I use the attribute linguistic shift, I address mainly the one issue. If a legal operation like judgment or contract drafting are to be handled through a computer program, obviously legal terms such as dignity or whatever right Professor Kervegan was referring to must be made available into the language of programming, very, very obviously. This entails what Garapon and Lasègue, in their book Justice Digital, have termed a grammatological revolution. So a revolution into the way things are written down, definitely in the idea of Derrida's grammatology, and a revolution that regards first and foremost the way in which things are said, and therefore also conceptualized, because as Anne was rightly saying, the way terms are used obviously relates to how the concepts these terms refer to are conceptualized, and hence a certain use of the term property or of the term dignity or the term equality or gender equity and so on and so forth entails to some extent a certain conceptualization, but also produces and will produce a certain conceptualization. So it has this double bind with the past uses, but also it has a projection towards the future uses of that term. And therefore, these practices, this algorithmization, so to say, of the practice of justice will definitely have an impact, and is having to some extent already an impact already through the way in which communication is dealt by through smartphones or other digital objects. Now, the transposition of legal terms such as, for instance, privacy or property or equality into the binary language of computer programming, so basically into zeros and ones, to use the expression that John Searle used in his Chinese room critique of artificial intelligence back in the 80s. This transposition into a binary language of computer programming is the source of a series of consequences also at the level of how the lexical competence changes. So the way in which these terms, these signs, this data, that's why my title refers to the term data. These basic and neutral data refer to definitely non-neutral concepts and much more complex concepts. So this is also a problem, the lexical competence and how it changes through so because of artificial intelligence. This is a problem that had been already discussed in philosophy of language in particular, already in the 80s, when artificial intelligence was already an issue. Then it had somehow a decline as a topic in philosophy of language, and now it has been revitalized after this broad digitalization, which is also impacting areas of our political institutions, such as law and justice. Now, against this background, I think it would be wise. I actually thought it wise, and because I did so I must think it was wise. But apart from the jokes, I think it would be very useful to go back to the question that mainly Bobbio and Scarpelli, but also scholars in those years after World War II. I'm thinking of, for example, Carnelutti. As I said, I'm mentioning mainly scholars in the Italian tradition, but the thing could be definitely enlarged, because the epistemological rise in that age was much broader than the Italian borders. But also Carnelutti with his Metodologia del diritto, or Luigi Lombardi Vallauri with this idea of legal science as political science. All these authors can constitute, actually, I think, a very fertile terrain on which we could revitalize and actually reanalyze the question, is law a science? And if so, what kind of science? That question in those years was not just related to the rise of that rationalist and epistemological turn, but that rationalist and epistemological turn was going back to the 19th century question, for example, asked by Wilhelm Dilthey about the difference between the so-called Geisteswissenschaften, so the sciences of the spirit, the human sciences, and the Naturwissenschaften, so the natural sciences. And in Dilthey, but also in Humboldt, this question was very important. It was a big question during the 19th century. The core issue was basically that natural sciences, such as biology or physiology or medicine, are basically based on data. I keep underlining this term because it's crucial, of course, within the artificial intelligence turn. Data in natural sciences are more somehow neutral. Just pass me the term because it's not the proper term, but they're data that can be explained in some sense just through themselves, whereas in Geisteswissenschaften, so in the human sciences, such as, for instance, also law, so Dilthey puts law within these sciences, the role of the interpreter is much larger. Now, of course, this is a huge and radical opposition, because we all know that science, like pure science, is also made of shifts of paradigms which require interpretation and require a brain to interpret what's going on. But what they wanted to underline is that in the Geisteswissenschaften, such as law, this role of the interpreter is really like somehow part of the production of the data. So somehow it's the perspective of the subject looking at the data is within the datum itself. And so this opposition, I think, is quite useful. And I think it resonates with what Anne was saying before, and also with what Professor Kervegan was saying to some extent, because there was the ghost of the intentional issue of the human intentionality behind the construction of institutions such as the law, that's how I read it. I think this whole somehow material of questions that we inherited from a past debate can be definitely brought back within the current debate, because somehow, if we start from the premise, as Anne Wagner was saying, that the data we work with in law are more results, in some sense, of a process of interpretation. That's why the opposition in my title, datum and result, what is already given and what is produced as something which is then used. Then, of course, if that premise is correct, or if we consider that premise as correct, then definitely the introduction of artificial intelligence at various levels of legal operations, contract drafting, risk analysis, data analysis, and even predictive justice, which is the phantom, which is of course behind all this, and which is, I think, the most, I wouldn't say scary, but definitely paradigm shifting one, the one that would really change things on the table. Well, if the first premise is true, then this revolution at various levels definitely entails not just a linguistic revolution, but definitely a revolution and a change in the way in which we understand law scientifically. And so it would entail a change in the answer to the question, is law and science, and if so, what kind of science, which was the very question that Bobbio and Scarpelli were addressing in the 50s in order to establish a certain autonomy of the law from other powers. At that time was the fear of again, the arbitrariness of the political power, because of what that generation had experienced after totalitarian regimes. But in this time, we could think of the potentiality of having the law being back dependent on another power. Could be also the financial power behind the big companies controlling artificial intelligence, the market, for example. I'm just dropping one potential example to say that the kind of issues behind the question of, is law a science, and if so, what kind of science do we want it to be, are much, much broader than the mere question of its scientific nature. So I would stop myself here, and I think I respected the timing, hopefully. Anyways, thank you very much for the attention.
Yes, you respected the time very, very well. Grazie molto, Professor Condello, for this also excellent presentation. I actually took a note and I wrote for myself for December to order your book, to buy it. You encouraged me, at least. And I will be very much interested. You know, it's an extremely important also topic. It's like we would all like, I think we would like law to be considered a science, but also don't take anything for granted, of course. And as a matter of fact, also we all, I think, read a lot. And sometimes we might ask ourselves, is this, let's say, 5-7 page commentary to a judgment really very scientific, as the author claims it is? It depends, of course. So thank you again. And I am now going to open the floor for questions and comments. We have even a little more time than scheduled. Obviously, it's a pity we don't have Professor Guastini with us, but we could start now, and I mean, to start the discussion. So I would warmly invite the participants to ask questions and comments. We would take at least a few, and then I would give the floor back to the panelists, maybe in the order that they presented, for their answers, feedback, and comments. Since we are all on the same platform here, so perhaps raising hand could be an indication that you would be willing to ask a question or present a comment. So dear participants, don't hesitate to do so. I am now, yes, I see already one hand. I am sure there might be more. So I will now invite Ms. Katarzyna Jaworska, but at the same time, I also invite others for questions and comments. We have at least half an hour, so that's a lot. All right, so the floor is now for Ms. Katarzyna Jaworska.
Thank you for allowing me to take part in this discussion. Very interesting and very insightful. And I have two questions. My first question is about the flexibility of law, or flex law. Now, Professor Wagner, you presented many, let's say, aspects of dynamics of the law, but my question is about flexibility or flex law and translation, and the problem of translation. Because if you translate from one language into another, you have to find the right equivalent. You have to, in a way, reconcile various meanings. So how does flexibility affect translation? And can you suggest any policies or any solutions to translator that grapple with the process of, on the one hand, preserving flexibility, and on the other hand, finding the right equivalent? And my second question is about the third presentation, Professor Condello, because you mentioned this relation between science and law. And the first thing that comes to my mind is corpus linguistics, or preparing right data analysis based on, especially in bilingual studies. But from my own experience, I know that even if you construct such data, you as a person who has to find the right meaning, you have to do it yourself. I mean, a database is not reliable, okay? So this science methods have certain flaws. So my question is, are there any limits, in your opinion, limits to this process of, in a way, subjecting law and legal studies, or also legal language to scientific methods? But thank you.
Thank you for these questions. I invite others also. I'm just checking the list to see if there were any questions and comments. The floor is still open. I might perhaps add a question or two, if you don't mind, from myself, but still, again, don't hesitate to raise hands and ask questions. Well, the panelists may also, of course, have questions themselves. I see the raised hand of Professor Condello. So I understand that that's would be you have a question for other panelists. Okay, so I will give you now the floor. Professor Condello, go ahead.
Thank you. Yeah, I had a question for Professor Kervegan concerning the function of intentionality behind all this ontology that he presented, with which I completely agree. I agree on the hybrid nature of rights as institutional and social objects. Because I know that he has a strong philosophical not just background, but of course he speaks from the philosophy, the perspective of philosophy, and he mentioned Searle, but he didn't mention Husserl. Obviously, he couldn't mention everyone. I just wanted to know what is your view of the function of intentionality intended as in the philosophical sense of representation, of projection towards an object within the construction of rights. If we accept your theory of a quite constructed and produced nature of rights. So, and there is also a note that I wanted to add. There is a wonderful works of Jean-Luc Nancy about the root and the justification of rights, especially of human rights in that case, which should, you know, because of Professor Balcerzak said that he's a human rights scholar. It made me think of that works, and there is an even one more level of complexification, because Nancy addresses the fact that those specific rights are justified through the fact that they refer and they're attached to the fact of being human. So and they are actually justified on conventions and on legal charters because of these, if we want, natural aspect. And so the level of complexification is even higher to some extent than compared to ordinary rights. So that was just my comment question.
Thank you very much, Professor Condello. Very interesting questions, and actually I very much also will be looking forward to the answers. I was about to also ask Professor Wagner to perhaps tell us a bit more about the limits of the doctrine. The doctrine of flex law sounds very interesting, but I'm very curious whether, whether or not you would tell us that there are some pretty much clear limits to that. So how far can we go when we apply this doctrine? And also, again, I would appreciate Professor Kervegan's comment, if possible. I hope it's not very provocative, but I would be very much interested to know if perhaps the ontology of human rights differs significantly from the general approach or not. I'm not insisting. Again, even though I admit it, that's my field, I am far from claiming that it is a completely different and legal environment. I wouldn't say so, but I'm very much interested in your views. So I don't see any more raised hands. So perhaps I would now invite the panelists for their comments and answers. And in the order of taking the floor, may I ask first Professor Wagner to take the floor.
So I will try to answer. It's really difficult to answer this type of question. Well, flexibility appears everywhere in any type of language, but it is really visible and highly visible in the context of law, simply because it is necessary. Otherwise, we will have to implement legislation for a specific case, and that's the reason why flexibility is always prevalent in any circumstances in the language of the law. Now, we had Katarina, she talked about how to translate this flexibility into another space and time. That's really difficult in terms of answer, because, well, I don't really like the term translate, simply because from time to time you can't really translate everything. So it's much more transplant or transfer of knowledge, of notion from one country to another. And from time to time you don't even have a specific equivalent in the countries where the translation have to be processed. And that's really the tricky role of legal translators and lawyer linguists, because they have to find a solution. And from time to time, it's not really a full and transplant and transfer of the original notion from the source language. From time to time, it is something that has been modified in order to fit the living reality of the target country. And even if you transfer these notions from the source language to the target language, there is always a loss in meanings, not a complete loss, but a loss in some of the meanings that were intended originally in the language of the law of the source country. And that's the reason why when you are talking with lawyer linguists or jury linguists from Canada or even from the European Union, they find a kind of hybrid mode of translation to make sure that they can still validate meaning in the target language that means something to the people of this specific country, even though part of the primary notion from the source country could be lost. So that's the reason why there's always a problem. And if we are talking about flexibility, we've got two types of flexibility. We've got the procedural flexibility, which is based on the analysis of language of the law in a specific context. And we also have the representational flexibility, which is based on the visual sign system that is used in many countries and in all the countries worldwide, comprising visual signs that mean and that convey specific legislation, regulation. Let's take the example of traffic road signs. Even though they have not anything clearly in writing, everything is done in terms of colors, in terms of shapes. And that's also really difficult in terms of analysis, because from time to time, from one country to another, these shapes could mean something else. And in terms of flexibility, the flexibility is necessary in the language of the law. Otherwise, it would be impossible to analyze, to have a clear interpretation from another space and time period, which is not the one where the original legislation, rules or regulation could have been enforced. And that's the reason why it's very difficult to transfer this flexibility from one country to another, because you have to somehow, when I'm talking to my students in translation, they have not only to learn how to translate, which is their first goal, but the second goal, which has to be really connected to this first one, is to have a comparison and to find the right, the most perfect comparison between the target, the source language and the target language. And this is also very difficult. It's not like a technical translation. Technical translation is very easy to process, while the legal translation, there are always risks. And many people in the European Union, in the international institution, are trying and are finding ways of contouring the problem by using a hybrid mode of translation, knowing that there's always something missing in the target language. But in any case, the role of the language of the law is to make sure that it is understood by the people of the target language. And so even though some of the primary information from the source language are not transferred as such, they still mean something to the target citizen. And this is the main role of legal translator, to make sure that it is understandable and applicable in a certain country, I think.
Thank you very much. And Professor Kervegan, vous avez la parole. Just make sure you're unmuted.
Sorry, it's okay now. Thank you for your very interesting question, dear colleague. It is a sign of the richness of the philosophical, of the discussion in legal philosophy in Italy. That is, for me, particularly impressive. I mean, it is the fact is that in Italy, the frontier between faculty of law and faculty of philosophy, not so important or so great, is as perhaps in France, for example, and so we can hear that in questions like yours. So to the question of intentionality, is a difficult question, of course, because so the original concept of intentionality, so I mean in Husserl and in the first phenomenology, was probably unable to give us a diversifying approach to rights, because it is known that Husserl have had a great difficulty to make the passage from ego to collective intentionality in the Cartesian meditations, those conferences in Paris. Husserl himself says, I have a difficulty to understand in a phenomenological perspective the transition from I to we. And of course, I mean, that is a great advantage of Hegelian insight to have a conception of I as a product of we in a certain sense, the phenomenology of spirit. But in the contemporary analytic philosophy, there are interesting attempts to give an approach of rights in terms of intentionality. I mean, especially his work of Searle, Making the Social World. In this book, there is a chapter on rights where Searle tries to explain basic rights, fundamental rights, as a product of collective intentionality. And I mean, as I can explain my critics here in details, but I mean that this attempt, that attempt remains insufficient because first, Searle as a philosopher has not a sufficient understanding of the complexity of rights. For example, the distinctions made by Hoffman into different kinds of rights, claim rights, liberties, etc. All that discussion since Hoffman, for example, in Steinberg, many Anglo-Saxon philosophers, contemporary philosophers, are totally ignored by Searle, and the result of that ignorance is that his concept of collective of engendering rights by collective intentionality poor is seems to me a little poor. We need a more complex approach of intentionality if we need such a concept to explain what a right, what the law is. And I mean your proposal to take in account what we can call a systemic approach of law is probably more productive. For example, the interpretation of rights in the work of Niklas Luhmann, the sociologist, is for me more productive as that of Searle, for example, because there is a deep understanding of the function of rights in the legal system. And so what I call ontology of rights is not meant as ontology in a neo-Aristotelian or approach or such a thing. By ontology, I mean we must ask the question, what is the being? What mode of being have rights? And this is what I call ontological question. If I can say ontology without metaphysics or with little metaphysics.
Okay, thank you very much. Professor Condello, would you like to comment? Do you have some further feedback?
Yeah, so, well, just a super brief comment on Professor Kervegan's answer, and then I have also to answer Katarina Jaworska's question. What a nice room you are in.
Yes, unfortunately, I cannot switch my camera on, right? So
No
I
worries.
cannot refer to you directly. So
I will just briefly comment on Professor Kervegan,
Yes.
so that because he just finished to speak, and it's a very complex. My answer to you, Katarina, is quite clearer in my mind than what I was elaborating. So I prefer to begin from the comment. No, thank you very much. I think I would be very happy to continue this conversation also further. I'm very familiar with Searle's work, and I was thinking of him. I translated some of his things into Italian, and I worked during my PhD in Berkeley. So I started from that kind of very contemporary ontology, but now through these works on method and science, I actually went back through Bobbio, who was famous, became famous as an analytic philosopher, but actually began with a thesis in philosophy. He began his career with a book on Husserl's phenomenology. So it's interesting, this connection between the philosophies of the first half of the 20th century, so to say, and then the analytic turn I was referring to after World War II. But anyways, the question I was asking you was precisely how you saw that kind of Husserlian idea of intentionality within the frame, and I completely agree that some accounts are not satisfactory enough, and definitely the complexity theory of Luhmann, and in general, I would say the whole Frankfurt school, so not just well, actually Luhmann was not precisely there, but there are German phenomenological accounts to law and rights, contemporary accounts, which are to this extent more satisfactory, although I find some of Searle's concepts such as status function, to which you referred, or well, collective intentionality is not Searle's concept, but the way he uses it is definitely interesting. I think his best examples are actually money, for example. So issues that are in between law and other kinds of institutions. The purely legalistic examples might have some flaws. So I completely agree with you, but I will certainly try to email you and stalk you to keep speaking about this, because I'm very interested. So my question to Katarina Jaworska, sorry for mispronouncing definitely your name, but hopefully your surname was right. So yeah, I agree. I think your comment confirms what I was trying to present today, and what is also the underlying thesis of the book I was referring to. So my idea is actually that if we embraced an idea of legal science as a natural science, so if we accept too much the possibility of analogizing between natural and social sciences, and hence to work in social sciences like we work in other kinds of science. So if we think that we could treat legal data just as we treat mathematical or physical data, for example, which might be interesting to extract some truths that might be useful, I don't know, for example, for climate provisions or for other kinds of things that in which algorithms might be useful. That could actually, in Italian we would say snaturare, so it would change the very nature of what law is. So I completely agree with you that also translations are good examples, as also Anne Wagner was saying, of how difficult it is to actually find the right correspondence, which sometimes is not an identity, often is not an identity. So it's actually there is a need for the interpretation, the interpretive process in between, which also entails, and that's my underlying thesis of the whole book, and also explains my question on intentionality to Professor Kervegan. That's an intentional process, the interpretive process. I think it's a process that requires the intentionality of a subject. And up to today, the only thing that we are certain of about artificial intelligence is that it does not have an intentionality. It can simulate and emulate the capacities of a human brain, but it cannot have an intentionality because it has no life, it has no ends, it has no telos, it has on and off. So it either works or does not work. And so that's a core difference between the human and the computational way of thinking, which I think your example, Caterina, confirms once more. So thank you for the question.
Thank you very much, Professor Condello. Well, I think we will wrap up in a moment. However, let me just perhaps well, I will not even attempt to summarize. There were too many interesting issues raised. We should definitely continue this discussion, preferably at the University of Szczecin. I believe it's a very good venue. You might have also noticed I changed my venue now because actually I wanted to show you something. What you can see behind my back are the places where interpreters work. I thought it's interesting. Well, I happen to be at the headquarters of the UN High Commissioner for Human Rights now, and we use the benefit of having interpreters a lot. We have been discussing about interpretations. It struck me, it was interesting what Professor Wagner said, that she dislikes the term translate and translation. By the way, I think it's in English and probably also in French, where you have this difference between translation and interpretation, whereas interpretation is also important for lawyers, isn't it? We don't have it in Polish language, by the way. There is just one term that refers to, well, putting in another language something from one language to another. Although obviously it's sometimes a difference if you do so from spoken language or if you do it from written language. And I'm just referring to that because in international law and human rights law, we have enormous issues with translating, interpreting, and from putting things correctly from one language to another. And these issues really are worth in-depth studies. I think that, well, obviously, also this linguistics aspect of law, and these are really very, very interesting fields. So having that in mind, and also that I don't see any raised hands anymore, but I also see that I'm sure that the participants would have more questions, but we would probably need to also give the room, so to say, give the floor to for the next panel. I actually also see some familiar names here. Well, it's very good to see Professor Jerzy Zajadło from Gdańsk, and best greetings also to other participants. But having said that, I think it's my duty as moderator or chair to wrap up. And I would like, first of all, thank the panelists very much for their excellent contributions to this panel. It was extremely thought-provoking. I also thank all the participants who logged in, all the organizers, and I very much look forward for the next opportunity to discuss these issues. I'm sure there will be one. So thank you very much, merci, and see you next time. Thank you.
Thank you very much. Thank you very much, Professor Balcerzak, for conducting the discussion. And I'm very grateful for all panelists for very interesting discussion as well. And hereby I pronounce a 10 minutes break. We see each other in 10 minutes. Thank you very much. Ladies and gentlemen, we are about to start our second panel, international panel, which I'm going to be the president over. And our first speaker is Professor Hans Köchler from University of Innsbruck. Herr Professor, das ist mein Vergnügen. Wir sehen uns das zweite Mal hier und ich freue mich, dass wir diese Gelegenheit hier an der Universität von Szczecin haben. Ich übergebe Ihnen das Wort. Bitte schön.
Danke für die freundliche Einführung. Ladies and gentlemen, greetings from Vienna. I will speak about nuclear arms and international law. Following the adoption of the Kellogg-Briand Treaty of 1928, recourse to war as an instrument of national policy has been increasingly outlawed by the international community. According to Article 3 of the treaty, the prohibition of the international use of force was meant to be universal. The original signatories envisaged, quote, adherence by all the other powers of the world, end quote. With the creation of the United Nations in 1945 and the eventual accession of almost all states to the organization, this objective has virtually been accomplished. According to Article 2, paragraph 4 of the UN Charter, there is no more general unqualified use ad bellum. The right to use force is limited to cases of self-defense under Article 51 of the Charter, with the notable exception of collective uses of force, according to Article 42. Not surprisingly, the respective government agencies were all rebaptized after these years as Ministry of Defense instead of, as earlier in some cases, Ministry of War. Thus, self-defense, individual as well as collective, is the only case where the question of the use of nuclear arms may come up. Like all other uses of force between states, acts of self-defense must conform to the norms of international humanitarian law. These include, first and foremost, the principles of distinction between civilian and military targets or objects, and of proportionality. This sets a very high threshold. Because of their physical nature, it excludes virtually all uses of nuclear arms. Nonetheless, international law regarding the use of nuclear arms has remained a field of legal ambiguity. In a dissenting opinion in the case of the 1996 advisory opinion of the International Court of Justice on the legality of the threat or use of nuclear weapons, Justice Schwebel from the United States mentioned two hypothetical exceptions for so-called tactical, namely low-yield nuclear charges in specific situations. The only two cases of a detonation of nuclear bombs so far, namely against essentially civilian targets in Japan, occurred before the provisions of modern international law were adopted. However, the Hague Conventions of 1899 and 1907 were in force in the year 1945. Recalling the laws of humanity and the dictates of the public conscience, these two conventions unambiguously state that, quote, the right of belligerents to adopt means of injuring the enemy is not unlimited, end quote. Article 23 of both conventions specifies in detail the prescribed uses of force, of which those described in paragraphs A, B, E, and C clearly also apply or would apply to the use of nuclear arms. The destruction of two major cities, Hiroshima and Nagasaki, was not a tactical but a strategic use of nuclear arms aimed at breaking the will of the Japanese people and ending the war by means, effectively, of large-scale terror, while saving the lives of one's own soldiers. This, in my assessment, may be the most dramatic case to date, where one can demonstrate that the end does not justify the means. No one was ever held accountable in a court of law. The principles of criminal responsibility defined by the Nuremberg and Tokyo war crimes tribunals were not applied to judge the leaders and personnel of the victorious armies. The Indian judge at the Tokyo tribunal, Radha Binod Pal, and the Chief Justice of the Supreme Court of the United States at the time, Harlan Fiske Stone, both succinctly explained why such tribunals could not be considered courts of law in the strict sense. Whereas in 1945, no specific regulations existed concerning the use of nuclear arms, the articles of the above-mentioned Hague Conventions nevertheless should have been applied. In the preamble to the conventions, the high contracting parties made it clear that they, quote, do not intend that unforeseen cases should, in the absence of a written undertaking, be left to the arbitrary judgment of military commanders, end quote. This was exactly the rationale also for the drafting of the convention's provisions concerning means of injuring the enemy, sieges, and bombardments. However, similar to other proclamations of guiding principles of law, such as the Universal Declaration of Human Rights of 1948, the Hague Conventions lack provisions for their implementation. They say nothing about what would happen if obligations under these conventions were not fulfilled. In that regard, one might say the Hague Conventions are a classical case of lex imperfecta. In several respects, this also seems to be the predicament of the regulations adopted by the international community in the last few decades concerning nuclear arms. The treaties are faced with major dilemmas, namely concerning normative contradictions, unenforceability, confusion between law and morality, and irrelevance. As is not surprising in a matter that affects the supreme interests of any state relative to the use of the most powerful weapons in human history, the impact of power politics or geopolitics on the drafting and interpretation of the documents may have been at the origin of these dilemmas and contradictions. And I can only give a few details here because time does not allow me to present the entire analysis, which I will make available in written form later. The 1996 advisory opinion of the International Court of Justice on the legality of the use of threat of use of nuclear weapons has made obvious a potential contradiction or incompatibility between two domains of international law, namely the general rules of war, including a state's rights to use force in self-defense against an armed attack, according to Article 51 of the UN Charter, and the principles of international humanitarian law, the jus in bello. In 1994, the General Assembly of the United Nations puts the following forthright question before the court. Quote, is the threat or use of nuclear weapons in any circumstance permitted under international law? That was the question. In its decision in 1996, the court stated, or in its answer, the court stated, quote, the threat or use of nuclear weapons would generally be contrary to the rules of international law applicable in armed conflict, and in particular, the principles and rules of humanitarian law, end quote. But the use of the subjunctive form and the subsequent admission of the court that it cannot conclude definitively whether the threat or use of nuclear weapons would be lawful or not in an extreme circumstance of self-defense, in which the very survival of a state would be at stake, the court has created more confusion than clarity. The ambiguity could have been avoided if the court would have acknowledged that any international use of force must be in conformity with the basic rules of humanitarian law. Why should, in a case of self-defense, the applicability of those rules be in doubt? Would the court also have hesitated when it comes to the use of chemical or biological arms? The ICJ should have been cognizant of the fact that the principles of the Hague Conventions still apply, and in particular the provision of the already mentioned Article 22. It should also have paid attention to the basic rule, namely Article 48 of Part 4 of the 1977 protocols additional to the Geneva Conventions of 1949, concerning the mandatory distinction at all times between the civilian population and combatants. The obligation applies irrespective of whether certain weapons are banned under specific conventions or not. In his dissenting opinion, Justice Schwebel rightly pointed to Lauterbach's position, according to which there, quote, is not the slightest relation between the content of the right to self-defense and the claim that it is above the law and not amenable to evaluation by law. The problem of incompatibility between the two normative areas, self-defense as part of the laws of war on the one hand, and the principles of international humanitarian law on the other, can only be resolved if international law in general is understood as rooted in fundamental human rights, similar to how the domestic legal order must be in conformity with human rights covenants in order to be legitimate. The indecisiveness and ambiguity in the advisory opinion of the ICJ reflects the Janus-faced character of attitudes vis-à-vis the first use of nuclear arms in 1945 against civilian targets. How to justify obvious acts of war crime or crimes against humanity, potentially also genocide, in the name of self-defense. How to defend the indiscriminate killing of hundreds of thousands of civilians in the name of higher strategic goals. We are faced here with complex legal and moral dilemmata to which the ICJ has no answers. The legal inconsistencies, even absurdities in matters related to the status of nuclear arms, and that is just a second example I will give here briefly, related to the status of nuclear arms in international law, have become especially obvious in a so-called interpretive declaration which France deposited on ratification of the Rome Statute of the International Criminal Court. In that declaration, France argues that the jurisdiction of the International Criminal Court over war crimes, in particular intentional attacks against the civilian population, is limited to instances where non-nuclear weapons are used. According to France, the Rome Statute, quote, can neither regulate nor prohibit the possible use of nuclear weapons unless nuclear weapons become subject in the future to a comprehensive ban and are specified in an annex to the statute of the court, end quote. It is obvious that this de facto reservation of France, in spite of the inadmissibility of reservations under the Rome statute, that this de facto reservation makes the jurisdiction of the court over all crimes utterly meaningless, namely if crimes committed by the use of the most devastating weapons are excluded from its jurisdiction. Interestingly, in the ninth session of the Assembly of States Parties to the Rome Statute in 2010, Mexico suggested that Article 8(2)(b) of the statute should be amended so as to include the use or threat of use of nuclear weapons as a war crime. This was rejected by the Review Conference in that year in 2010. In their session in New York 7 years later, the states parties, however, amended Article 8 to include weapons which use biological agents or toxins and other especially injurious weapons. This makes, in my view, the omission or exception for the most destructive and inhumane arms mankind has ever invented even more scandalous. Putting the use of nuclear arms effectively outside or above international law is, I would say, an example of legal isolationism that exclusively serves the interests of nuclear powers. That the Treaty on the Prohibition of Nuclear Weapons has in the meantime entered into force, namely in 2017, does in no way change the situation, as long as the nuclear powers do not accede to it. A ban proclaimed by the nuclear have-nots is, in my view, not a comprehensive ban in the meaning of the French declaration. And that brings me to my concluding remarks. The state of affairs will not change in the foreseeable future. Due to the nature of power and the deep mistrust it creates between countries, nuclear states will not accede to any treaty that obliges them to abandon their dubious privilege. That the international community, first and foremost the General Assembly of the UN, has repeatedly stressed jus cogens aspects concerning the illegality of the use or threat of the use of nuclear arms, declaring it as contrary to the laws of humanity and a crime against mankind and civilization. That's the terminology of the UN General Assembly. All of this has no impact in terms of the enforceability of the existing treaties, and the least so of the Treaty on the Prohibition of Nuclear Weapons. As matters stand now, with only 68 states having ratified the treaty, and those states whose interests are especially affected by the treaty, namely the nuclear powers, staying away, there is also no chance that the norm of prohibition might attain the status of customary international law. What remains is a striking antagonism between law and morality. Also, there is an inescapable vicious circle between power and law. The law, to be effective, would need to be enforced by those, namely the permanent members of the UN Security Council, who, as nuclear powers, are not prepared to make it enforceable. Thus, the belief in a universally valid prohibition of nuclear arms will, unfortunately, remain wishful thinking for the indefinite future. Thank you for your attention.
And it's sad to say, it's very, very current at the moment. Lately, suddenly we woke up in the reality that matters related to the nuclear weapons and law are are current again. Once again, thank you very much. A very fruitful and very inspiring speech. Our next speaker is Professor Giulio Itzcovich from University of Brescia. Buongiorno professore, siamo felici di averla qua. Sono molto curioso e il tema della sua relazione mi interessa tanto. La passa la parola, prego professore.
Thank you. Can you hear me? Thanks. So thank you for the invitation and for the floor. I would like to briefly explain why I was attracted to this topic, judicial deontologies and the practice of legal reasoning. It basically depends on the difficulty I experience when I try to explain to my students the relation between legal theory and the practice of legal reasoning, which are basically the two components of the discipline I teach, theory and techniques of legal interpretation. By legal interpretation, I mean what one may call legal reasoning in practice, that is the set of arguments lawyers employ in arguing a case before a court, the kinds of reasons judges rely upon in justifying their decisions. So, while theories of law is the bread and butter of legal theorists, so it comprises various claims about the nature of law, about analysis of the concept of law. And at first sight, the relation between the two notions, legal theory and the practice of legal reasoning, may seem quite close, no? So, for example, if one embraces imperativism and defines the law as a set of general commands addressed by a political superior, by the sovereign, to his subjects, it follows that in case of doubt on the content of the law, one has to take into consideration the intentions of the legislator, no? Since the will of the sovereign is the ultimate source of legal validity, it should also be a relevant criterion for legal interpretation. And indeed, we find, for instance, Hobbes, the nature of the law is not its letter, but its meaning, which is the intendment, the sense of the legislator. On the other hand, if one embraces natural law theory and defines the law as ars boni et equi, the art of goodness and equity, or even remaining within the confines of legal positivism, if one maintains that the legal system can include morality, so that the validity of a legal norm can depend on its consistency with moral principles, then one will acknowledge that recourse to moral reasoning by the judge may be appropriate or even necessary. No? And finally, a third example I'd like to provide, the German historical school, Savigny. If one embraces that legal theory and claims that the law originates spontaneously, organically, incrementally from the Volksgeist, the national spirit, which basically expresses itself through customs, precedents, and legal doctrines, then it's clear that the law, being the product of history, has to be interpreted in the context of time and place, and has to be interpreted in ways that are consistent with its organic unity and systematic harmony. So historical and systematic interpretation are to be preferred. Natural law is in principle, and the intention of the legislators are in principle irrelevant. So the relation between legal theory and the practice of legal reasoning appears quite close, rather closer. Legal theories, well, first of all, legal theories often have a normative component. They are often addressed to the legal scholars and practitioners and provide them with standards of judgments. And even when this is not the case, legal theories usually must reflect practice in a meaningful way. They have to make sense of practice and cannot be entirely detached from it. Moreover, theoretical questions often emerge from practice. Legal scholars and practitioners critically reflect on the reasons why they use the reason they use. And this second-order inquiry on legal reasoning, it might be one of the original impulse to develop legal theories. So the relation appears to be quite close. However, on closer inspection, the relation between legal theories and the practice of legal reasoning is less straightforward. than these examples suggest. So, for instance, Hobbes himself says, I'm quoting, "The intention of the legislator is always supposed to be equity. For it were a great contumely for a judge to think otherwise of the sovereign." And we know that natural law theory, natural law can justify recourse to moral reasoning, but it can also exclude that moral reasoning is admissible. It can justify an exception to the law, but also obedience to the law as established by the civil authorities. And Savigny himself said that the law is based also upon the human nature common to all, and paved the way for standards of judgment such as equitas, naturalis ratio, boni mores, various kinds of utilitas, that is moral reasoning. So at most one can acknowledge the existence of elective affinities, so to say, between legal theories and models or patterns of legal reasoning, but no direct mechanical relation. So in order to articulate the relation between legal theory and legal reasoning more thoroughly, I was drawn to what one may consider as an intermediate level, no, between the higher level of theory and the lower level of practice, which is judicial deontology. By judicial deontology, I mean what we might also call normative theories of adjudication, or theories on the virtues of the judge. What is a good judge? What kind of virtues should he or she possess? And I think that I've at least four coexisting and occasionally competing theories on the competing judicial deontologies can be identified. And that's the topic of I'd like to address. So the first one is the mouthpiece of the law, the legalistic judge, who possesses two basic virtues. First of all, knowledge of the law, which can be knowledge of the legal texts, knowledge of the legislator's intentions, the precedents, the systema juris, whatever. The point is that whatever the law is, it is a subject capable of being known objectively. There's a technical element of the law, which is different from the moral intuition of what is right and wrong. Everyone can make a moral judgment about some topic, but only the educated jurist, the mouthpiece of the law, is capable of confronting that moral judgment with the body of objective legal knowledge, and eventually, if necessary, set aside his moral judgment and comply with the existing law. So that's the second virtue of the judge as mouthpiece of the law, fidelity to the law. He is ready to comply with the law as it is. He believes that it is his duty to do so, at least under normal circumstances. This is not a matter of moral insensitivity, a matter of being overzealous or simply lazy. The judge as mouthpiece of the law can easily spell out the political values attached to the rule of law: legal certainty, equality before the law, and the integrity of a certain institutional arrangement where the powers are divided and the legislator bears the responsibility for the collectively binding decisions. So the judge's mouthpiece of the law is characterized by a vast and perfect knowledge of the law. He may think of himself as a legal scientist, and is characterized by this unyielding willingness to apply the law as it is, thus fulfilling the duties of his office. He is impartial. He might be a bad Christian, as Luther said, Jurist and böse Christian, but he is a good judge in the sense that he knows the law and is faithful to the law. So, what is the impact on legal reasoning of this very important, mainstream, and predominant model of judicial deontology? But I would say that a whole array of different legal arguments become available, which we may call formal legal arguments, in the sense that they are not based, at least not explicitly so, on a moral assessment of the case. So the judge may resort to literal interpretation, the plain meaning of the text, to the legislator intentions, the settled case law, the system of concepts and principles developed by legal doctrine. In all these cases, the judge does not openly reveal the indeterminacy of the law and does not take responsibility for the decision, but attributes the decision to a higher and impersonal source, the law, the will of the legislator, the will of the state, the legal system, of which he claims to be the mouthpiece. Second, judicial deontology, the Solomonic judge, whose characteristics are wisdom, fairness, equity, prudence, practical virtue, and so on. He feels that he has a responsibility not towards justice in the abstract sense, certainly not towards legality as such, but first and foremost towards the parties to the dispute, the concrete individuals before the court. His duty is to render justice to litigants, and to do so he may occasionally depart from the formally established rules of law. If necessary, the Solomonic judge is ready to depart from these general laws to uphold higher principles of morality and to achieve the justice and to achieve justice of the case. So he's an exemplar of the Aristotelian phronesis, the virtue of deliberating well and acting according to reason, so as to obtain the best possible results and achieve happiness. Formal legal arguments are not irrelevant, as equality and legal certainty are instrumental to the protection of the individuals, and yet formal arguments often need to be supplemented by other considerations that assess the outcome of the case on the basis of a notion of substantive, sorry about that, on the basis of a notion of substantive justice. So many examples or anecdotes, see this maxim by Edward Koch, non solum quid dicet, sed quid est conveniens considerandum, not only what is permitted, but also what is convenient is to be considered. And this quotation by Giovanni Battista De Luca, who was a cardinal in the 17th century and wrote a book, Dello stile legale, about the legal style, which is quite interesting, about the judge's honesty, doctrine, and commitment to the legal studies are useless if he is not able to grasp the point of the case, and if he does not know how to adapt the law to the particular circumstances of the case at hand. What matters most is an application of the law that is appropriate, adapted to the need. So, in terms of legal reasoning, various kinds of substantive arguments come to the fore. The judge takes it upon himself the responsibility for saying what is right and proper under the circumstances of the case. Obviously, there's an elective affinity between this judge and natural law theory, as there's an elective affinity between the mouthpiece of the law and legal positivism. There might be an elective affinity between legal realism and the third judge or legal deontology, the judge as a social engineer, who feels he has a responsibility not so much towards the parties to the proceeding, but towards society at large. And he's not so much interested in injustice in the concrete case as in social utility and welfare. The judge as social engineer conceives of the legal materials, the rules, the principles, the doctrines, precedents, as tools to an end. And like an engineer, he creatively combines them to achieve desirable social goals. He builds using the available materials, aware of the constraints in which he moves. In a way, he is also a scientist, but of a quite different kind compared to the mouthpiece of the law, because knowledge of the legal material is not enough, and it's purely instrumental. In order to be meaningful, that knowledge has to be supplemented by an understanding, first of all, of society, of an understanding of the society to which the law has to be applied. And secondly, also an understanding of the political goals the law is meant to pursue. So a good judge does not just know the rules of positive law, but understands the policies of which they are an expression. With regard to legal reasoning, the most characteristic arguments of the judge as social engineer. Well, first of all, he will prefer probably pragmatic considerations, prognostic judgment, forward-looking arguments that are based on the foreseeable consequences, practical consequences of the decision. He will probably prefer purposive or teleological arguments based on the aims pursued by the legislature and directed towards realizing those aims to the greatest extent possible, And finally, he will make use of balancing judgment and proportionality tests to justify decisions on the ground that they satisfy the relevant interests to the greatest possible extent again. So, and contrary to the Solomonic judge, he will be particularly interested in those aspects of the dispute that identify typical situations that are likely to arise in a variety of cases, instead of the peculiar, the particular that De Luca was interested in. Final and conclusive model of a judge or judicial deontology is what I call the dialogical judge or the deliberative judge, which is in a way something at first can appear quite recent, or instead maybe it's not the case. But let's take this decision by the German Constitutional Court of 1987, so not that recent. Kloppenburg, the German court says the judge has never been la bouche de la loi, has never been the mouthpiece of the law. The European Court of Justice has developed the law in new and creative ways, like a sort of social engineer. The European Court of Justice has developed the law in new ways, but this is not unheard of in the history of Europe. And most importantly, this is happening in cooperation with national courts by means of preliminary ruling procedures. So the underlying idea, the idea that national and European courts are engaged in a relationship of mutual cooperation, engaged in a dialogue, is a recurring theme of European Union law, and is also, I would say, a purely juridical idea, a purely legal concept, in the sense that there's no political connotation. It is neither pro-Europe nor anti-Europe. It can be used either to embrace and foster the project of European legal integration or to oppose it. So, and we see over the past 20 years, there have been many rulings, many judgments in which the court states that it intends to cooperate, or even explicitly to enter into dialogue with other authorities, and especially with other courts. This has happened with regard to the relations between the national courts and the ECJ, but also with regard to the practice of judicial borrowing. Judicial borrowing, the quotation of foreign precedents, has sometimes been regarded as a kind of dialogical interpretation triggered by globalization, especially in human rights law. It makes sense for for a Supreme Court to listen, to pay attention to the arguments employed by other courts, by other jurisdictions facing similar cases. Note, here there's nothing absolutely new, because this dialogical judge belongs to the law of European integration, if you want to, judicial globalization, the emerging global community of courts. But it also belonged to the law of jus commune and ancien regime society, both pre-modern law and post-modern law, so to say. The ancient concept of judicial comity, comitas gentium, has always expressed the idea of due deference towards foreign law, and more broadly, deference towards the opinions expressed by other authorities, especially, but not exclusively, when the background reference system was Roman law, conceived of as ratio scripta, written reason. This kind of willingness to pay attention to how other courts have decided similar cases was relatively common. So we all share a common reasonableness, so to say, which is Roman law, and we should listen to each other. And we find this idea of the deliberative judge or the dialogue in Montesquieu himself, who is not just the mouthpiece of the law, but speaking about adjudication in tempered monarchies, he says, in monarchies, the judges choose the methods of arbitration. They deliberate together, they communicate their sentiments for the sake of unanimity, they moderate their opinion in order to render them conformable to those of others, and the lesser number are obliged to give way to the majority. So these judges, his virtues are, he's reasonable in the sense that he is able to raise and sustain a claim to correctness. In justifying his decision, he spells out reasons that can be appreciated from the perspective of other legal systems. He doesn't say, according to the German constitution, things are this and that, but it expounds the underlying principles that can be understood and shared by other authorities. And secondly, he is accommodating and deferential. He shows deference and a certain degree of willingness to mediate and find compromise solutions to common issues. So he feels he has a responsibility not only towards the law as such, not only towards the parties to the dispute, not only towards society at large, but also towards other authorities, especially judicial authorities. Distinctive arguments, and I'm concluding, borrowing the citation of foreign precedents, but also the notion legal concepts and principles such as the principles of openness to international law, Völkerrechtsfreundlichkeit, reference to the constitutional traditions common to the member states, the margin of obligation doctrine before the European Court of Human Rights, deference, comity, and general balancing test and proportionality judgment. These are the characteristic arguments employed by this final the dialogical judge. And yeah, that's it. Thank you for your attention.
Thank you very much for this speech, Professor. And I'm quite convinced that there is going to be some questions related to it. Our next speaker should be Professor Juan Ruiz Manero, who is unfortunately absent today. And the next one is Claudio Michelon. Is there a Professor Michelon with us? Professor, if you are with us, could you please raise your hand up at the screen? I don't see anything. Therefore, I believe I can pass the word to our next speaker, Professor Gerald J. Postema from the University of North Carolina at Chapel Hill, USA. And the professor is going to give us a paper entitled Reflections on the Nature and Value of the Rule of Law. Professor, the floor is yours, please.
Thank you very much. I'm pleased and honored to be here today. I want to speak about the rule of law. Dante once wrote of justice that it's so lovely that it's loved even by its enemies. This is even more true of the rule of law. Although the rule of law ideal imposes irritating constraints on those who exercise power, it enjoys a halo of legitimacy. But a consequence of this is that it is vulnerable to capture and rhetorical abuse by those who would retain the halo, but minimize its costs. The rule of law currently is under grave threat. Watching other nations struggle to turn back assaults on their core rule of law institutions, people have begun to ask each other, can it happen here? Journalists, pundits, political leaders, and people on the street regularly utter and debate questions about the intelligibility, moral force, and viability of the rule of law. However, before we rush to concoct policies or programs to remedy these dangers, we would do well to linger a while with the ideal, feeling its weight, sounding its depth, listening to its call, and measuring its threats and challenges. That's the task of a book I have just published called Law's Rule, the Nature, Value, and Viability of the Rule of Law. In this book, I articulate a coherent, comprehensive, and I hope compelling conception of the rule of law and defend it against challenges to its intelligibility, its relevance, and its normative force. Let me say a bit about the structure of this conception. At the center of the rule of law ideal lies a worry about power. Power's a tendency, if it is unconstrained, to be exercised in arbitrary ways. Throughout its long history, the ideal has been shaped by a twofold thought. A polity first, a polity is well ordered and its members are accorded the dignity rightfully demanded by them in the name of their common membership when its members are secured against the arbitrary exercise of power. And secondly, law, because of its distinctive features, is well equipped to provide such security. The rule of law provides a bulwark of protection, a bridle on the powerful, and a bond constituting and holding together the polity and giving expression to an ideal of association. When law rules in a political community, it provides protection and recourse against the arbitrary exercise of power through law's distinctive tools. Thus, the organizing aim of the rule of law is to temper the exercise of power, and law is the chosen means of doing so. This ideal has two distinctive characteristics. First, it claims normative force. Yet it is one principle of political morality alongside others, complementing, sometimes competing with, other fundamental principles of morality. Secondly, the rule of law is an institutionally realized ideal. It exists only insofar as institutions, norms, and practices give concrete expression to its principles in historical political communities. Let me say a bit about the task of this conception of the rule of law. A coherent conception of the rule of law must do several things. First, it must articulate its key concepts like power and the arbitrary exercise of it. Secondly, it must elaborate and defend its constitutive principles. Third, it must look both upstream to the political moral principles from which the core ideal flows, and downstream to the structure of institutions, organizations, norms, and practices that give substance to those principles. Fourth, it must face its limits in the material and cultural circumstances of particular communities in which it seeks to take hold, and in its competition with other principles of political morality. In view of the complexity of this ideal, it is not surprising that it has been a magnet for confusion and controversy. The conception outlined in my new book, Law's Rule, enables reasoned reflection and argument about the rule of law, its constituent principles and foundations, its relations to other fundamental principles of moral and political morality, and it enables assessment of varying attempts to realize it. Let me outline some of the main features of this conception. The core idea and basic component concepts and principles. Against the abuse of ruling power, the cure, according to the rule of law ideal, prescribes law's rule. Law rules in a political community when it, as I said before, when it provides protection and recourse against the arbitrary exercise of power through law's distinctive tools. The power in question is power of one party over another in relationships characterized by dependency and inequality. This power is arbitrarily exercised when its exercise is unilateral and not subject to accountability. The rule of law is concerned with power wherever it's located when it's used to dominate others, thus with private as well as public governing power, whether exercised within the boundaries of nations or beyond them, whether exercised by governments or individuals or digital platforms. The rule of law seeks to temper rather than disable governing power, to discipline power in law's distinctive ways, thereby providing protection and recourse against its abuse. A key to the success of law's rule lies in the existence of effective mechanisms that hold those who wield power accountable for its exercise. Now, I argue that three principles immediately follow from this core idea of the rule of law. I call them sovereignty of law, equality in the eyes of law, and fidelity. Let me mention briefly something about each of these principles. Sovereignty. Law must rule. This idea implies three subordinate principles. One of them is I call exclusivity. That is, the principle that all governing power must be derived only from and is ordained exclusively by law. That's exclusivity. Legality. All governing power must be exercised through or by means of law, and law must meet key standards of formal and procedural legality. Third, reflexivity. Law governs all, especially including those who govern by law or govern with law. Reflexivity. Those are the three subordinate principles of sovereignty of law. Second principle, equality. The principle of equality, tailored to the ambition of the rule of law, demands that law's protection and recourse is available on an equal basis for all who are bound by it. Finally, fidelity. Sovereignty requires that law rules. However, we have known since ancient times that law can rule only if a robust ethos takes root in a political community. The rule of law includes not only the formal, procedural, and institutional standards of legality, it also comprises a set of relationships and responsibilities rooted in core convictions and commitments that are essential for the realization of this ideal. Fidelity is the term I use to capture this thought. It requires that all members of a community, not merely the legal or ruling elite, take responsibility for holding each other, and especially law's officials, accountable under the law. Fidelity, I believe, is the animating spirit of the rule of law. Moral foundations of the rule of law. Rule of law demands that law rules, but by what right? It calls on members of the political community to participate in a practice of mutual accountability. What justifies this kind of active allegiance? The rule of law also is a middle-level political principle that stands between fundamental values of political morality on the one hand that ground it, and the institutions or practices that realize it. It's a distinct value existing in a constellation of important values of political morality. Its moral standing and its normative force depend on the deeper values that it serves. I argue that the rule of law serves a complex moral value I call membership. This value puts individual dignity, equality, or what I would like to call peerhood, community, and freedom from subordination to the will of others in a close, internal, mutually qualifying connection. Membership stands resolutely opposed to the subjection of some to the arbitrary power of others. Moreover, because the ideal of membership seeks coherence over time for communities and for their members, it calls on law, uniquely designed for this purpose, to provide the needed protection against such subordination. Law, when it meets the demands of the rule of law, plays a key role in securing and nurturing communities aspiring to realize the value of membership. Let me say a bit about the relationship between the rule of law to other principles of political morality. Democracy, respect for fundamental rights, and the rule of law are distinct values. They issue from distinctive normative demands. Nevertheless, they are complementary and intertwined. Fundamental human rights can adequately serve vital interests of human beings only with the assistance of law. In turn, the law and its administration, conforming to the demands of the rule of law, serve their grounding values only when the law adequately recognizes and protects these fundamental rights. Now, it is possible for a legal system to meet rule of law principles and standards and yet fail to protect against systematic violations of basic human rights. However, where this is so, the government's commitment to the values served by the rule of law is fundamentally compromised. Similarly, democracy and the rule of law are distinct, but they exist in a unique relationship of interdependence. The rule of law supplies the necessary infrastructure of democracy, while democracy is, you might say, the natural completion of the ambitions that motivate the rule of law. Let me say a word about the institutional realization of law as rule. The rule of law is an institutionally realized ideal. It exists only insofar as its institutions, norms, and practices give concrete expression to its principles in actual political communities. So it makes demands on the institutions of government, on centers of social power, and on the behavior of citizens and officials through a series of downstream standards adjusted to political and social circumstances that can vary across political communities. These standards include, for example, the following. The rule of law makes specific demands on law itself, on the formal conditions of legality, generality, prospectivity, followability, and the like, excuse me. It also makes demands on institutions for the application and enforcement of the law, principles of procedural fairness, access to justice, and the like. It calls for institutions that constitute, constrain, and sanction the exercise of ruling power. These include, for example, separation of powers within a government, a network of mechanisms of what we might call horizontal accountability within the government. In a modern state, this calls for a kind of quasi-fractal separation of powers between and internal to the separated branches. In addition, informal constitutional norms underwrite formal institutions. They delineate and enforce the autonomy of the agencies while defining modes and limits of accountability. The rule of law depends heavily on extra-governmental organizations and practices that are rooted in civil society. These institutions must be protected by law, for example, protection of freedom of speech and association. These institutions and practices of civil society provide the necessary means of what we might call vertical accountability. Finally, essential to the realization of the rule of law is a robust legal profession that understands and is deeply committed to the rule of law. Lawyers are conservators of the law and guardians of its integrity. They play a crucial role in tempering power and are essential intermediaries between law, citizens, and the institutions of officials of government. A word about the limits of law. Because the rule of law is an institutionally realized ideal and one principle amongst others, it faces two kinds of limits. First, the institutions and practices that realize the rule of law depend for their meaning and efficacy on the specific material, cultural, and legal conditions of those communities. And these conditions can vary. So the rule of law institutions might well take a variety of forms to take advantage of distinctive resources and answer to the distinctive challenges that this variability offers. Weakness of rule of law institutions in political communities may not lie so much in their initial design, but in the underlying cultural conditions. Secondly, there are also normative limits to the law's rule of law's demands. The rule of law is only one concern of political morality amongst others. Its place in the web of moral values fixes the boundaries of its proper scope. In some circumstances, the rule of law may have to give way to more pressing demands of justice. In addition, the rule of law is limited because proper reach of the law is limited. In some contexts, the law is just off limits because its intrusion into those areas is too costly. Finally, a bit about the threats to the rule of law. The rule of law is vulnerable to a variety of threats. The law is threatened in a political community when its institutions are weak or unable to respond flexibly to challenges in domestic or global circumstances. It's threatened when political actors seek to subvert the formal institutions that realize the rule of law or the norms and practices that animate them. It's threatened when responses to attempted subversion lack vigor and conviction, and when the moral culture in which the ethos of fidelity exists is corrupted and political spaces in which accountability can flourish shrink. Let me say a bit about the challenges to the intelligibility and normative force of the rule of law so understood. I'll just mention one of them here. The rule of law relies on robust practices of vertical accountability. It encourages protest, resistance, whistleblowing, and even in some cases, defiance of those who claim authority to speak in the name of law. This poses a challenge for the rule of law, of course. Fidelity wars with finality. It threatens to throw law into perpetual uncertainty, undermining the protection and order that the rule of law seems to promise. We must deal with this challenge, but not by explaining away the tension between finality and fidelity, or by rejecting one or the other. Rather, we must explore ways to manage what I call the delicate dialectic between deference and dissent, a dialectic that lies at the very heart of the rule of law. The rule of law insists that law rules, not any individual's or institution's understanding of it. Hence, every exercise of power, including authoritative determination of what the law says, is in principle open to challenge, disagreement, and dissent. However, due weight must be given to competence and credentials of those to whom the law has allocated decision-making power. The rule of law recognizes the need and appropriateness of civilian and official deference to authorities, but their decisions are also subject to challenge. Thus, civil dissent, even defiance of directives from authorities may be legitimate. So too may resistance by officials be legitimate, although I must add, official resistance is indeed subject to stricter limits. This challenge, like others we might consider, provides to be a challenge for defenders of the rule of law resolutely to address and seek to answer them, but they are not ultimate challenges to its very intelligibility, normative force, or feasibility. Let me conclude with these words. Our conviction regarding the rule of law are not anchored in worship of law or belief in its magical power, but rather in a realistic recognition that the law is an indispensable means by which the dignity, equality, and common membership of each person in a political community are acknowledged and served. Every member of the community owes a duty of fidelity, not to the law or to their government, but to each other. Keeping faith with the law is a primary means of keeping faith with each other. Commitment to respecting and serving the rule of law springs from a commitment to work in concert to resist arbitrary rule and domination, and to create conditions in which the community can unite to seek justice. In this effort, the rule of law marches arm in arm with democracy and key fundamental rights, human rights. This commitment inspires a charge to accept the responsibility to realize the rule of law in our political communities. The rule of law is a bold and demanding ideal. It's a dare. Often we think of the rule of law in terms of rules, procedures, formalities, institution. But rule of law institutions cannot protect themselves. Neither courts nor parliaments can secure it without the committed and mobilized engagement of the people of the community. We must look beyond those institutions to the animating spirit of the rule of law, the fidelity, the ethos of the members of the political community. Law rules in a political community only when the ethos of fidelity is deeply rooted in that community, when all members of the community, official and non-official alike, take responsibility for holding each other to account under the law. Thank you very much.
Thank you very much, Professor. I'm very grateful for this speech. If I may express immediately some feelings of mine, I admire the construction of your speech. It was very, very well ordinated and therefore clear and logic. Thank you very much. Our next speaker is going to be Professor Claudio Michał, who represents University of Edinburgh, Scotland. Senhor professor, eu li que você tem uma origem brasileira, então me deixa falar um pouquinho a sua língua.
Mas claro.
Isto torna ainda mais agradável para mim dar vos as boas-vindas a Szczecino, a nossa universidade. É prazer veramente dar vos a palavra. Por favor, senhor professor.
Thank you very much. Muito obrigado. That's very rare that I am greeted in my native Portuguese in an international conference. So thank you very much. Excellent Portuguese, by the way. And thank you for the invitation. I'm flattered by the invitation and also glad to have the opportunity to talk a bit about some of the issues that interest me in my current research. As we do have limited time, and let me also apologize for having joined just a few minutes ago. As I told Dr. Beata, I've been moving from meeting to meeting today, but from now I should be focusing on the seminar. So I'm going to try to make a claim now in the next 20 minutes and then motivate that claim. So the claim I'm trying to make is that our current theory of precedent is not fit for purpose. It's inadequate. It's not necessarily wrong, but it's insufficient. It cannot explain how courts use precedents in their decisions. The importance of doing that is not only for common law systems, I don't think. There's a movement in many civilian jurisdictions towards using more and more the idea of binding precedent or the idea of authoritative precedent, either by superior courts or by appeal courts or combination of both. So, but I think that the theory you have to understand it, to understand how precedent works, is not fit for purpose. I do think that we need an expansive theory that explains more than what we have. And I think that has implications for the way we see the law in more general terms. Now, the strategy to try to motivate that claim is to simply show you. So it's almost an ostensive definition. I'm going to try to show you how the conception of precedent and the theory of precedent we have now is unable to explain a lot of the kinds of arguments that happen in court. And I'll do that by showing you, first talking about the standard case on which the standard theory is based, the idea of applying a precedent, and then moving to explain to you two ways in which precedent is used that actually don't fit the theory, or at least not so much they don't fit the theory cannot explain, has no resources to explain those uses, they are widespread uses. My claim is to show you those two objects, those two kinds of use of precedent. But of course, the objective is much broader. I don't have time to do that, but I think that those two exemplars, as it were, that I pretend to put to you, they are two out of many, many other exemplars. And in paying attention at the types of use, the types of arguments that embody and embed authoritative precedent, we then can start building a more comprehensive, a more adequate theory of precedent. So what's the standard case? So the standard case is going to be the case of applying precedents. I'm going to spend 2 or 3 minutes with that. And then I'm going to talk about precedent-based analogies, which is the first object I want to present to you, and then precedent-based inferences to the best legal explanation. IBE is inference to the best explanation. So those are the two objects I'm going to present to show the doctrine is not sufficient. Very well. So the traditional doctrine of precedent, so not the theory, but the doctrine of precedent, is often usually very succinctly formulated as the court that's under an obligation to follow precedent has an obligation to either follow or distinguish. So either the court does what the other court that set the precedent did, follows what they did, or distinguishes it. We can add also that some courts can overrule precedents. Yeah, the House of Lords from now the UK Supreme Court from 1966 onwards thought that they settled the questions that they can overrule their own precedent. So either you apply the precedent or you distinguish it, or if you are one of those courts that has the power to overrule its own precedents, you can overrule it. Now, there are 4 things that perhaps we can use. I don't know if you have the handout that I circulated, but if you don't, there are 4 things you can say about this doctrine and the theory that explains this doctrine. So first of all is that so what's the precedent used for? What's the precedent used for? And it's used to support a particular decision on a particular issue by a court. So I bring to you a particular to the court a particular case, and the court's going to use that particular precedent that they found, or more precedents they find, to try to settle a particular case. Now, settling a particular case is something that's common between, I think, precedent application and analogies, but not necessarily inference to the best explanation. So the first thing I want to say about the current doctrine of precedent is that it focuses only in one type of usefulness for the precedent. It's usefulness to settle a particular case. But there's a second thing. And the second thing has to do with the claims or assumptions that an argument that applies precedent has to rely on. Yeah. So when I apply a precedent, I have to rely on the existence in the previous case of something like a normative. It could be a rule or a reason that there's debate out. There's a debate between those who think like myself, that think that's a rule, and those who are like Grant Lamont think it's a reason. But it's a normative standard, let's call it. That normative standard is going to be applied to the particular facts of the case. And that movement of application is often modeled into some sort of legal syllogism. So what you have is a universal premise for every X, and for every, if X has the properties A, B, and C, then the court decision ought to be decision D. And then you look at particular case, you see the A, B, and C are present. And so it's what we normally call the legal syllogism. There's debate as to whether or not the legal syllogism is the best way to express this idea of application. But let's go with it for now. For my purposes here, let's pretend that there's no controversy, that what you do when you apply a precedent is to apply a normative principle of some sort. It could be a rule, or it could be a reason, a normative standard of some sort to a particular situation. Now, that problem is the one that's been tackled more often by the theory of precedent. And around that, a whole vocabulary was formed. So we have things like the distinction in the previous decision between the ratio decidendi and the obiter dictum. So we look at the decision that is binding on us, that is as authority over us, and we think, okay, they said lots of things, those judges, what here is part of the ratio decidendi, what is part of the obiter. And the ratio would be either a rule for people like myself, or the ratio should be not a reason, but a particular number of reasons that together are sufficient to establish the conclusion. But what you have is this idea of separating the decision between what is really binding and what's not, and what you're looking for is some sort of conditional statement. I'm going to talk about that conditional statement, that's just a rule, but nothing changes much for my purposes here today, whether that's a rule or a reason. And also these ideas of distinguishing and applying. So once I have the ratio decidendi, then I can check to see if it applies to the case. And then remember, the doctrine is that I have to either apply or distinguish. So if the cases are covered by the antecedent of the conditional, then I apply it. Or I say, well, there's something different about this case. And so I have a burden to explain what's different and why I'm not going to decide in the same way. Now, notice that in the standard formulation of the legal syllogism, there's a third feature of precedent application, which is the fact that it yields a particular type of conclusion. Because the doctrine of precedent is that courts are under a duty to either apply or distinguish, or overrule, but apply or distinguish. What it yields is a duty to decide in a particular way. So the conclusion of the legal syllogism is not simply that is actually that the court has to decide in a particular way, has a duty to decide in a particular way, right? And I have to rush here. And okay, so there are four things that you can see if you have the handout. You can see there are four things that seem to be what the traditional doctrine of precedent is trying to account for. Is trying to account for the use of precedent to decide particular cases, by establishing a duty to the courts, duty to either apply or distinguish, and has a whole vocabulary and apparatus that helps us apply. So a distinction between obiter and ratio, a distinction between distinguishing and applying, and so on, between persuasive authority and binding authority, and so on. Now, if you look at the precedent base, so that's the standard account that we have, and we have a particular form. The form is the legal syllogism, right? So that's the argument. It relies on the existence of a rule or something like a rule or normative standard, and in order to yield the conclusion. Now, I don't think that the same happens in legal analogies that depart from precedent, or in even the best legal explanation. So let me try to demonstrate that. So in precedent-based analogies, there's something similar to just the application of precedent, which is this idea of trying to sort out the solution for the particular case. But there are three differences that I find are overlooked if you don't by the traditional theory of precedent. First of all, is the types of claims it relies on, right? It relies on a claim about an authoritatively settled case. A certain case has been authoritatively settled. it relies on the assumption that there is no authoritatively settled case applicable, that there's no settled law, no other case or legislation applicable to the case. It's one of those cases that courts call cases of first impression, or cases where there's no settled law. If there's settled law, there's no need for you to use the analogy. So, because you have a duty to decide according to the settled law. But sometimes, and in many courts, they start analogies by saying, look, there's no settled law here. There's no precedent that applies directly here. So, but we have something similar. So it relies on the fact that there's some case that's been decided that ratio doesn't cover the instant case. No other ratios cover the instant case. No other bits of legislation cover the instant case. And it relies on a claim of similarity. So the case that's been decided is similar in some respect to the case that we have to decide now. So what's called the source case is similar in some respects to the target case, the case I'm trying to decide now. So I need to have an authority. I need to have a precedent that binds me. It doesn't settle the case directly. The ratio doesn't cover the case. But I think that this case is so close, the case at hand is so close to that other case that I want to extend the same solution for this other case, right? And accordingly, because this is not within the strict realms of the doctrine of precedent, it's not very clear. Well, the court doesn't seem to have a duty. It's not a doctrine of precedent. It's just a authoritative precedent. And so this authoritative precedent is crucial, is important for us to be able to make the analogy. Yeah. That it has authority is important for us to make the analogy, but the authority is not used here directly by applying it, because it doesn't apply. And so what it gives is something weaker. It's not a protected reason like a duty is. It's just a reason to decide in a particular way. Yeah. And that explains why you can have competing analogies. You can have a number of different analogies that within the same legal system pull in opposite directions. You can have reasons to decide in a particular way, but also reasons not to do it. Yeah? Now, there's a third thing here that I think is a difference. And in the kind of account of analogies that Luís Duarte de Almeida and I came up with a few years ago, that would be a difference, but not in the most traditional conception of legal analogies, which is the one that is everyone else in the world, apart from me and Luís, has defended. So from Golding to Cass Sunstein to everyone. And it's this idea that Luís and I don't think you need to actually state what the similarity is for an analogy to run. Yeah. So we don't need something that looks like a rule. What connects those cases is A, B, and C. And whenever A, B, and C are present, then the decision is. So there's nothing like a universal conditional in the argument. So if you have the handouts, I have in the handout I have legal analogies, two models of analogy. The Golding one, which is the best, probably the clearest statement of it, and mine and Luís's one, which is very different. And you can see that the difference is that premise 4 that tries to establish tries to create a burden for someone who is using the analogy to explain exactly what the similarities are between the cases, that premise, Luís and I think, is unnecessary. So if we are right, another difference between precedent-based analogies and simply cases of application of precedent is that we don't rely on anything like a universal conditional or a functional equivalent to universal conditional for an analogy to run. So you see that there's a difference here that is significant. So we use precedent, we use them authoritatively. The analogy only runs because there is authority in the precedent, but that authority is not used to, it doesn't settle the case, it's not part of settled law. So we use it for these cases in which the law is not settled. Okay? We can go back to that later on. The last example I want to give you is the use of inferences to the best explanation. So here's the claim. Here's what I think. So sometimes courts make inferences that look very much like inferences to best explanation. So think about decisions like Lord Denning's dissenting opinion in the Bundy case, in which he, I think wrongly, but it doesn't matter because the argument, the structure of the argument is what matters, in which he takes 5 cases or types of cases and he says, well, from those 5 cases, we can infer a general principle, right? And we see Lord Atkin in Donoghue versus Stevenson doing something similar. There are many cases of negligence in English private law, or in that case, for Scots law, but in many cases of negligence peppered around the law. And what we need is a unified principle. He calls it the neighbor principle and so on. And we see that in a more recent decision of the then House of Lords by Lord Gough, in which he departs from 2 or 3 cases or types of case and say, well, from those 2 or 3 cases, we can infer a doctrine of change of position in the law of unjustified enrichment, a general principle of change of position as a defense. In all those cases, what we have is a movement from a series of discrete ratio decidendi, or cases, if you prefer. And from those, you build a more universal principle. Now, here, if I am right and Luis is right, and you don't need something like a principle to make an analogy, there's a sense in which the courts here are acting in a way that is slightly supererogatory, right? So, because they could do just an analogy, and but they do more. So it suggests that there are 2 things going on here, that those kinds of use of precedents to establish a general principle, they are used to support one of the premises of the analogy. And so strengthening the argument, making it more robust and less vulnerable to the charge of being unsound, of having a false premise. But also it looks like courts are actually talking to one another, when it's very typical of that sort of construction that that the court says things like, the time has come for us to do this, and I don't want to establish the principle or to phrase the principle in any more certain ways than blood in this particular formulation, and I leave it to future courts to refine it and so on. So clearly, the audience here is not simply the parties; they are talking across to different benches or different times. Also, the inference here doesn't seem to be relying on the existence of a particular subset of norms. And what it gives you in relation to the particular case is, again, like the analogy, the reason to act according to that more universal norm, to apply the neighbor principle and decide in favor of Ms. Donoghue, to apply the change of position and decide in favor of the defendant in the plaintiff in Lipkin Gorman and so on, or Mr. Bundy in the Lord Denning's decision in Bundy. So what we have here is two different sorts of arguments for which, in which we don't rely on the existence of previous universalizable claims, in which we don't establish a duty that the court has, but in which we rely on the authority of precedent. So the authority of precedent is not simply useful for application, but is useful for other things. And a theory of precedent that doesn't account for all those other arguments and types of arguments and uses in this area in which the law is not settled is a theory of precedent that's inadequate. And there are 2 interesting things here, yeah. So, or a number of interesting things, but one of them is that what it seems to happen here is that we have a situation in which we don't have settled law, but we have not run out of legal argument. So those analogies are not analogies with morality or just arguments that depart from the moral beliefs of the judges. They're still departing from the law, albeit not settled law. It's not law that clearly covers the case, but still. So when you run out of settled law, perhaps you still have law to go on by. The second thing that I find interesting, and with that, so there might be more things between heaven and earth than dreams our legal philosophy. Perhaps there's more space for understanding the law than simply understanding the law as something that's applicable or applied to instant cases. And accordingly, a range of different possible conclusions that judges can reach that might resolve the case, but in very different ways. So having a duty is a protected reason, having a reason is just having a reason. Yeah. So I probably spoke for too long. I've lost track of how long I've been speaking for. But just to conclude, those two that I presented to you, analogies and inference-based explanation, just to I'm more familiar with. But you can think of arguments like the a fortiori, often used by courts. You can use arguments like a contrario or a contrario, the assimile, and all those cases. In all those cases, those are arguments that are based on a legal authority. In my case here, for the purpose of this paper, precedent authority, but that are not covered by the precedent. They are legal resources we have beyond settled law. Thank you very much.
Thank you very much, Professor. It was very, very interesting to me because some time ago I noticed that in spite of the fact that Poland, my country, we are governed by a total different legal system based on the German solutions invented mostly in the 19th century. Practically, we are using precedents. We are quoting precedents. And the thing is, we don't call them precedents. Therefore, well, that's the paradox. It was very, very interesting. And once again, thank you very much. If I'm not wrong, I'm recognizing the old college up there. Yes, wonderful place.
That's right.
Okay. Yeah, exactly. Well, ladies and gentlemen, we've got some time for a discussion, which I'm opening now. If there's any questions, it's a very good time to ask them. Just raise the hand and we'll give you the word, please. Anyone? Okay, Professor Postema, I see your hand. Please go ahead. Ask your questions, please. We don't hear you, Professor. You have to unmute.
Now you do, I bet.
Thank you very much.
Very good. Thank you all, and especially Professor Michał. I confess I'm very sympathetic with the direction of your thinking on this matter. And correct me if I'm wrong, but I'm inclined to put your general point in a slightly different way, but it may be consistent with yours. And that is, when people have thought about precedent and theorized about precedent, they wanted to draw really strong distinctions between following precedent, arguing from analogy, and some inference to best explanation. Whereas it looks like they merge. They're very much interactive, such that, strictly speaking, arguing from precedent in the way in which your theorists have talked about it depends heavily on analogy, because you can't understand what the category of the rule is unless you understand what the cases that fall under it are, and they're never going to be exactly the same, right? They're going to be in interesting ways different, but we ignore those differences. So it looks like we're doing more like thinking by, you can't apply a concept unless you've got examples of the concept in mind, you might say. The same thing goes for precedent. I mean, if you're going to understand what that rule is, you got to see it fitting into a larger context of rules or principles. And there's going to have to be some kind of reconciliation of them, coherence amongst them, you might want to say. And that involves something like, maybe not strictly speaking, inference to the best explanation, but something like that. I once argued for an account of analogy that really does make just the point you want to make, namely that it can't plausibly appeal to a background rule because what you have is a collection of interestingly similar but also different cases, not some background rule that already explains it. So I wonder if this way of construing your point is consistent with what you wanted to say.
Thank you so much, Professor Postman. That's very, very useful. And I think that that's, I think that there are two things going on, really. So one of them is a looser sense of an analogy. In that sense, like a comparison. Yeah. And in that sense, I couldn't agree more. Clearly, when you're departing from a particular precedent, you're looking at the particular case in front of you, you want to see some sort of similarity. And that influences the way in which you build the ratio. So there's sometimes, because you see that there's something going on that's so similar between the cases, you build a ratio in a particular way. So that comparison is clearly part of the background of trying to establish this universal that is the ratio decidendi. But I think that there's something else going on as well. So there are cases, I'll give you an example. There's a famous New York case, you probably know it, called Adams. Everyone uses Adams as an example of analogy. So, including myself. So the idea that in that particular case, the court starts by saying, look, we have authority here. The authority, it was a case of money stolen from the cabin of a steamboat. And the question was whether or not the steamboat owner, the company that owned the steamboat, had strict liability without fault without negligence to just repay the money. And what the court says in Adams, which I find interesting, is to say, look, we have no authority. There's nothing about steamboats in the law. There's nothing about cabins. There's nothing about anything. What we have, though, is an old established principle. I think it comes from Roman law. They don't say it, but I think it comes from Roman law, which is the rule about innkeepers' liability. So, well, we know that innkeepers, the hotel owners, they are liable, strictly liable, if money is stolen from there. So that rule doesn't cover our case. We're not talking about hotels here. And they say that they start the case by saying they're similar, but it's not enough for us to stretch the ratio of the previous cases to cover this, because in interpreting the ratio, it was very clear they meant only hotels, didn't mean anything else. And in fact, there are competing precedents on trains. In train berths, you don't have liability, strict liability. So they look at that and they say, well, okay, so yes, it's not covered. So that's the initial sense of analogy, of a comparison, was not sufficient for them to stretch the ratio in such a way that they can just now apply the ratio. So what they did was say, okay, the ratio of innkeeper's liability continues to be about hotels. But if we decided that case in that way, there seem to be good reasons for us to decide this one in a similar way, because look at the cabin. The cabin has this property and this property and this property. It's close. So they seem to be so close that whatever answer there is should be a similar answer to both. So if the previous case was decided with strict liability, I cannot think of any reason why this one shouldn't be established as strict liability. But see, the court then didn't think of themselves as, or of itself as having a duty to do it, because there was no settled law. They were actually in a bit of a quandary. What do we do? Now, sometimes it's enough for the initial comparison for us to understand the ratio in a more enlarged way, and then we can just apply the precedent. But not always. Sometimes that would do violence to the language of the previous court, like they thought. And then all that's left for us is to say, well, perhaps we run out of settled law. We don't have settled law here. But have we run out of law? No, because there's some law and something very similar. We have to keep the same track. So those two movements are analogical in some respect. And the first one, I think, is part of Rupert and Cross and everyone who writes about those things. They see that, and I think that's true. What I'm just trying to say is that there's another use of analogy that happens precisely when the ratio is not sufficient, when there's no ratio. So you see that in, just very incidentally, we see that also in legislation. Yeah. So there's a famous German, so Karl English mentions a famous German argument about opening exceptions to self-imprisonment. So a student, a very good student, knowing he was acratic, had no strength of will, he asked for the principal of the university to lock him in the library overnight. And so he was locked. He panicked, police came, and then criminal prosecutors are prosecuting the principal for false imprisonment. And then they said, look, okay, fine, it is false imprisonment. But there's an exception here for tattoos in bodily harm. When it's consented, it's not very... Shouldn't we actually analogize that to also see an exception here in false imprisonment? They're so similar. So clearly there was no law opening an exception, but the court thought, yes, but let's extend that by analogy. Sorry, I spoke for too long, but thank you so much. That's there's so much more I want to say, but I don't want to monopolize it. Thank you.
Thank you very much, Professor. I see the hand of Professor Timothy Endicott from Oxford. Please, Professor, ask your question.
Thank you so much. I hope you can hear me. I hope it's okay to ask two questions. One for Professor Itzcovich about a small detail in your presentation, but it got me thinking during Claudia Michelon's presentation. I really liked the idea that comity is a virtue not just between nations or between institutions of nations, but between authorities in general, I think you suggested. And you talked particularly about courts and how judges ought to show respect for each other's carrying out of their role. And I wondered, is that the rationale for a doctrine of precedent? That's my question to you. And to Professor Postema, I was thinking during your presentation about forms of state action that are barely controlled by law. The United Kingdom is a very legalistic country, but there's virtually no, or perhaps no control at all by the law over the Prime Minister's appointment of ministers. Now, in a situation like that, I've got thinking about this because of what you said about conflicts with other moral principles. I can think of two ways of explaining the rule of law. One is to say that it's irrelevant because the Prime Minister's choice of a defense secretary should not be controlled by law. To understand the rule of law, we have to understand what law ought to be controlling, and it shouldn't be controlling that. Or would you say that the law should control everything subject to the need to respect other principles, and there might be other competing principles that give reason not to have judicial review of the reasonableness of the appointment of a minister? And then you said that action is arbitrary and therefore against the rule of law when it's unilateral and not subject to accountability. Well, I got thinking about voting. That's unilateral and not subject to accountability in a good democracy. In the UK, not since the 1870s when they brought in the secret ballot. No accountability and unilateral. Is that contrary to the rule of law? And maybe you could think of my first question as a question about that too. Does the rule of law simply, is it irrelevant because law shouldn't be controlling my choice of candidate in an election? Or should it control everything subject to the need to account for other principles? Thanks.
Okay, who'd like to answer the first question? I mean,
should I answer? There was a question for me. Yes. So yes, very briefly, if the doctrine of comity can be interpreted as the ratio for the doctrine of precedent, which I think it's possible. Obviously, the doctrine of precedence, as I understand it, can be justified also on different bases. It's compatible also with other, so to say, deontologies. We can, I think, provide also a very legalistic understanding of the doctrine of precedent. And or we can also, in a way, celebrate the virtue of the doctrine of precedent as a way of incrementally building the law and developing the law from case to case towards an acceptable and, so to say, built from below arrangement of the law. So there are various reasons that can be provided for the doctrine of precedence. Comity, however, as I understand it, one of its defining features is that it applies when there's no duty to obey, so to say. There's no duty to obey. Well, precedents are meant to be binding, although it's a very, they are very defeasible, and it's a very, so to say, low degree of bindingness that precedents express. But nonetheless, they should be binding. While comity applies, as I understand it, when it's just as a matter of courtesy, so to say, or deference towards foreign jurisdiction. So in a way, it best fits, for the reason why I mentioned it is that it best fits this notion of dialogical judge, or judge which is in a way engaged in a conversation with authorities where no hierarchical structure, no system of course, is in place. So that was, I don't know if it answered the question. Thank you for the
Thank you very much. And the second question?
Yes, thank you, Timothy. I recall a similar question you raised when I presented some thoughts about this several years ago. Let me start from the end and move up to your more interesting, also interesting question about prime minister power of appointment of ministers. With regard to voting, there are two ways to approach this. The one is to say, yes, we're keen that there not be accountability in that context, but that's because we judge on other grounds that this is a place where law is off limits. We have good reason to think law should not be engaged in that, or accountability to law should be engaged in that in certain areas. Of course, law should be involved in the protecting of the exercise of that, protecting the exercise of it, not in determining the content of that exercise. So you might want to say this is a case in which, like, for example, the exercise of power in domestic domains, we might want to say that's an area where law is off limits as well. Though this is a question about the relative importance of law and rule of law in competition with other important principles of, say, privacy with respect to the domestic relationship. Of course, in that domestic relationship context, it's not anything that goes on in that domain which is beyond the exercise of and influence of law. There are certain exercises even within it that we want to say law should worry about, should care about the abuse of that power. So it's going to be a moral question, a question about how we should, where and when we should engage the law, that we might want to address this particular question. Now, the influence of law in the domestic context is an interesting one in this respect, because it contrasts with the exercise of the power, both of the voting power on the one hand, and the power of the prime minister to appoint ministers on the other hand. And that is, we got a I'm very careful early on to describe the kind of power, what I mean by power, in the context of this discussion of the rule of law. And power, in my view, that's the concern of the rule of law, is power that is exercised over parties in context of inequality, though interdependence of the parties. So an asymmetry of the power. Now, there are powers, of course, of appointment. There are powers of voting, which are not powers over others. I call them in some contexts, when it comes to the exercise of the power of the prime minister, the power of position. That also can be abused. But we're talking about a different kind of power than the one that I think is at the heart of the worry that the rule of law has. So there are actually three ways of addressing the question of whether there should be control by the law over the prime minister's exercise of appointment of other ministers. One is law shouldn't be involved in that. That's just beyond the limits of law's intervention. Or you're right, that's one. Another is that law should control, but it's in conflict with another principle. Third is, and I'm inclined to take this view, though maybe a combination of this plus the first view, that it's a matter of not the core concern of the rule of law, that it is a power of position, a legal power, but not a power over persons to get them to do things that those who exercise the power wish them to do. In which case, it doesn't fall immediately under the, if you will, the umbrella of the worry of the rule of law. There are wonderful subtleties in this. Think of the power of pardon, for example. I'm inclined to think that the power of pardoning is an important power that has to be controlled by law. So I've got to be careful about how we draw these lines. I agree with you, but it's in the subtleties of understanding the nature of the power as power over, and the moral principles that might lie behind it as well. Thank you, Timothy, for that important question.
Thank you very much, Professor, for your answer. I believe we've got time for two more questions. I've seen the hand raised by Professor Katarzyna Jaworska-Biskup from our university, and I noticed also that Professor Hans Köchler would like to ask a question as well. Professor Jaworska will go first, and then I will pass the word to Professor Köchler. Professor Jaworska, the floor is yours, please.
Thank you, Professor. Because we are running out of time, so I will ask you only one question or maybe a comment to Professor Michał. So I was wondering about intertextuality. So precedent as a kind of intertextual notion. And especially the theory proposed by Peter Brooks or Greta Olsen that claiming that a legal case or legal text is a kind of narration, okay, or kind of a cluster of various narratives. So my question is about intertextual relations between one case and another. And do you think that this narrative-based approach in a way helps in finding precedent, in establishing precedent? So this is my question, so thank you.
Would you prefer me to answer just now or wait for the second question?
Yes, please. Yes, yeah. You can answer.
Thank you very much, Katarzyna. So I think it helps, but intertextuality has, so the claims that are made often about this narrative is that that it can be the touchstone by which we can understand certain source of authority, not only in precedent, but also more generally. So I've seen claims about civil codes that certain articles of civil codes are effectively narrations of certain stories. They're very stylized and very abstract, but they are effectively narrations of certain stories. So I've seen the same claim made in relation to pieces of legislation. And if you look at UK legislation in particular, often you have these long paragraphs in which you're trying to tell a story about something, yeah, in some pieces of legislation. But I do think that the way in which they are more directly amenable for us to understand decisions that apply precedent is through the step before the argument forms that I was talking about, which is interpretation. So a lot of this intertextuality allows us to see dimensions of the text that we couldn't see before. So there are stories that are told. So Bernard Jackson has a wonderful book on law narrative and coherence and narrative coherence, and it makes more or less this point that sometimes this story that's being told helps us understand the meaning of what came before. Yeah, so even old precedents can be given a new light by the fact that we now can fill the story with more detail. Yeah, so we know better what it was meant by the other court, even if they didn't psychologically mean it. What could have been justified that decision after we have this growth in the. So I think that intertextuality has clearly a bearing on interpretation, determining what the ratio is, what the arbiter is, reinterpreting old precedents as well. Now, it also might have a role to play in determining the. So if you buy into Grant Lamont's conception of precedent as reasons, he says something which is really interesting. I think the conception of reasons is wrong, but he says this: look, every time a court decides a case and applies the precedent, there's a new story that's being told. So we learn the law changes because there are a series of things in the new case that the court's deciding are not sufficient to defeat the previous case. So the court is deciding, even when they apply the precedent, because the new case is so different, what they're saying is that all those features that are there are not good enough to distinguish. So next time a similar case with some of those features shows up, now the court is bound. It was not bound after the second decision, after the first decision, it's bound now. So this intertextuality actually builds into this idea of incremental change in the law, even when we apply the law. So even when you apply the law, you're not creating new precedent, you are creating new law, because now you know that certain things are not sufficient to distinguish. So I think in those two ways, intertextuality, perhaps more, but in those two ways at least, intertextuality can have a role to play in us understanding how precedents work. But thank you.
Professor, and it's time for our last question. Professor Köchler, you have the word, please.
I have two questions that are interrelated to Professor Guastini, and I try to be brief because it's so late now. First, can there be a rule of law without democracy? Second question, is there an international rule of law in the present system? And just to explain briefly how these two are interrelated. The United Nations organization is the one that advocates or that states that it is based on the international rule of law. However, the basic decisions on the implementation of the most essential or most important norm, namely the prohibition of the use of force, are made by procedures which are not compatible with democracy, but which are governed by national interest. Namely, the permanent members of the Security Council can veto any decision about implementation of this prohibition of the use of force, and they can do so according to the statute, even if they are themselves the aggressor state. So we have an organization that proclaims to act on the basis of the rule of law, while in actual fact, it is based on a statute was drafted by way of a compromise with power. And if this is the case, if we say, or if we maintain that there is something like international rule of law and that the UN represents that system or ideal, should one then not say, okay, in this case, rule of law can exist without democracy, because at the UN it is implemented, the laws are implemented not according to democratic rules, and not, by the way, according to to the idea of the law, because national interests may override any decision to prevent or stop an act of aggression. That is my question.
Thank you very much. Thank you very much. I'll try to be brief as well. Two really critical questions, those, and they are interrelated, I understand. And I appreciate the special application of the first question to the international law context. In general, as a general point, I want to argue that the rule of law can conceivably exist in the absence of democracy. The rule of law is, however, likely to be in various ways compromised by the absence of democracy. And surely democracy is deeply compromised without the robust rule of law. The international context is really quite interesting, however, then, because, and here we have to be careful, while I want to argue that the rule of law is a principle that appropriately applies to and binds us in the international domain, nevertheless, the rule of law can be weaker or stronger in different kinds of social political context. And it seems to me that the rule of law is still, unfortunately, rather weak in the international context. And part of the weakness may be due to the fact that there is the way in which power is distributed over states and other actors in the political domain is insufficiently democratic, let's say non-democratic. So my view is that in the international domain, there is room for us to think seriously about the rule of law. We can worry that the rule of law is not robust enough there. And maybe one of the reasons why, though this would require much more argument, maybe one of the reasons why it's not robust enough is that it is not working closely enough with institutions that serve best our ideals of democracy. The same thing goes for international human rights, of course. So I think these are all deeply intertwined questions. My main concern is to argue that the rule of law is relevant, is an important principle of normative force in the international domain, though that domain may not adequately serve those principles well. Thank you so much for your question.
Thank you very much, Professor. That was our last question, and therefore I'm closing the second panel. I have to say that it was a great honor to be the president of the session, and due to this chance I had a unique opportunity to learn a lot, for which I am very, very grateful both to the referents and disputants. The next panel will be presided over by my colleague, Professor Olgierd Bogucki from our faculty, to whom I will pass the presidency now, and I wish you all good luck and fruitful conference further. Thank you very, very much.
Welcome. Hello, everyone. My name is Olgierd Bogucki. I will chair the sixth panel of our conference. I am honored and pleased to announce 4 scheduled presentations followed by discussion. I'm pretty sure that there is a large dose of great legal theory and legal philosophy because our speakers are excellent scholars. We are grateful to them for accepting our invitation. Therefore, without further introductions, allow me to ask Professor Nigel Simons from the University of Cambridge to present his paper entitled Heart, the Concept and the Idea of Law. Professor Simons is known for his excellent works like Debate Over Rights, Moral as Law Idea, Central Issues in Jurisprudence. Professor Simons, it's an honor that you are with us today. I give you the floor.
Okay, thank you. I don't know if you can see and hear me, can you? Can you hear me?
We can hear you.
Yes, we can hear you, but we
and you can't see me.
That's correct.
Yes.
I'm not very used to this technology, I'm afraid.
Technology.
That's it. Right, thank you.
Right.
Okay, well, I'll kick off straight away, and I'll start by explaining the sort of two general interests or concerns underlying the remarks I plan to make. I've always been very interested in the scholarly professorial aspect of law. And I think this is largely because I've always really thought of jurisprudence as a reflection upon the role of law in our civilization. And I think that the aspect of law that I would call its professorial or its scholarly aspect, its highly systematic quality, this is really the core of law's role in our civilization. And it's a sad criticism of Anglo-American jurisprudence that not only has it given very little attention to these issues, but its intellectual framework is very ill-suited for dealing with them. I've tried in a very limited way to engage with these issues in my own work. And for example, in my book, Laws of Moral Idea, I have a passage, a short passage, which I will read out now. I say the rules enacted by the powerful seem to become law only by their absorption into a system and a body of ideas transcending the totality of enacted rules. Law seems to be not the builder's yard full of materials, it's the edifice that results when they are put together in the best way. And that is an edifice that is always an ideal that has to be achieved rather than a given. So I'm here trying to say that law really only becomes law when it's presented in a systematic framework as it is by jurists and at their best by judges, though judges often fall rather short on that front. Okay, now that's my first concern. I'm trying to explore that idea a little bit more. And my other concern is this. In the work of Kant, or going further back, Plato, we find the notion of an idea in a rather distinctive sense. And it even appears in the English Romantic poet Samuel Taylor Coleridge in his great work on the constitution of church and state. He begins by drawing a distinction in between what he calls conceptions and ideas. And he says this, he says, conceptions bring any given object or impression into the same class with any number of other objects or impressions by means of some character or characters common to them all. We comprehend a thing when we have learned how to comprise it in a known class. Ideas, on the other hand, are not abstracted from any particular state, form, or mode in which a thing may happen to exist at this or that time, nor yet generalized from any number or succession of such forms or modes. Rather, an idea is given by the knowledge of a thing's ultimate aim. Now, of course, Coleridge was really one of the first English scholars, and I think probably the first English scholar, who had immersed himself in the German philosophy of his period. And in these passages, he's clearly drawing upon Kant. But even so, it's worth focusing on Coleridge rather than Kant, because great philosophers like Plato or Kant are often very concerned about the systematic coherence of their own theory, and they often say things which are addressing that type of concern. Whereas a poet like Coleridge is simply reacting to human experience and his knowledge of human culture and human civilization. And Coleridge is finding this distinction in between conceptions and ideas a fruitful one for understanding the subject of his book. In other words, state and church, his twin themes in that book. So I found myself wondering if the idea of an idea in Coleridge's specific sense might help us understand the scholarly aspect of law rather more than the approaches which are more or less standard within Anglo-American jurisprudence. I keep saying Anglo-American jurisprudence simply because my understanding is that the idea of an idea of law has played a part within German jurisprudence, but I know so little about German jurisprudence, I'm not really qualified to engage with it. Now, it helps, I think, if we remind ourselves of exactly what the problem addressed by jurisprudence fundamentally is. And it seems to me that the problem, the philosophical problem of law's nature, arises in something like the following matter, the following way. Although people often say that law is a social practice, that's often a sort of throat-clearing exercise at the start of a talk or a lecture. People say, well, law is a social practice. Actually, that claim is very questionable. And if you set off on that foot of saying law is a social practice, you obviously face the question of, well, since social practices are observable in some sense and are studied by the social sciences, why is the nature of this specific social practice a philosophical question? And the answer you usually get is that, well, the philosophy of law is concerned with the criteria that serve to distinguish this type of social practice from other types of social practice. So you have the idea that jurisprudence is offering a typology of social institutions, as Joseph Raz says. That, it seems to me, is an incredibly impoverished way of understanding philosophy of law. The questions we're addressing go right back to ancient Greece. They're as old or almost as old as philosophy itself. They may well be as old or almost as old as law itself. And these questions did not arise from some sort of primordial urge to find a clear typology of social institutions. That idea is ridiculous. They arise in a completely different way. What we encounter when we look at social practice is not social practices which are law. We find a multiplicity of different, very complicated social practices, all of which involve reference to something that the participants in those practices call law. And those references embody assumptions about the nature of law. The difficulty arises as follows, that when in a reflective hour, we try to identify those assumptions and out of them construct some sort of coherent account of the abstract objects seemingly being referred to within these practices, we find that they don't easily combine. For example, and all of the points I'm now going to make will seem completely familiar. We assume that laws are made by human decisions or human acts of some sort, but we also assume that human decisions, human acts can create law only when they're legally authorized. Infinite regress. You have an infinite regress of laws authorizing the law creating human actions. It's the very familiar idea that law authorizes its own creation. So that's one problem. How does that work exactly? How do we block the infinite regress? Second problem is this. We all assume that the content of law hinges upon the materials of things like statutory enactments or judicial precedents. If you want to know the content of the law, you have to look at things like that. They determine its content in some way. But the content of law is not reducible to the totality of statutes and precedents. We know that full well because we know that expert lawyers can actually disagree about law's content even when they're fully familiar with the contents of the statutes and precedents. Now, I know that one can dismiss that. Raz had an early article he published in 1978 where he said that these things were just a rhetorical or ceremonial or ritualistic aspect of the law. So that seems to imply an early urge on his part to say that law really is just the totality of statutory enactments and law reports. We might have such a conclusion forced on us, but it should be a reluctant conclusion if we're trying to understand the place of law within our civilization. We should approach our conventional understandings and the forms of speech which reflect those conventional understandings in a more sympathetic way, trying in the first instance to see if we can make sense of them. Okay. Third problem is this again is very obvious. Law is typically invoked by judges as a justification for their decisions, and those are decisions which may involve imposing sanctions on people. So when we think about the idea of law, it's a very strange idea. It's the idea of something which can authorize its own creation. It hovers uncertainly above the materials on which it depends for its content, and it has a mysterious power to justify coercion. A skeptic would say, well, obviously you're looking here at an ideological illusion. It's an ideological gloss upon the raw facts of power. But we shouldn't reach that conclusion too easily, because if we say that, we're also abandoning a lot of ideals which most of us hold very dear, like the rule of law and indeed like liberal democracy. So that's a conclusion we should try to avoid. We should try to make sense of this idea, not simply say, well, it's just a myth, it's an ideological illusion. Okay. Now, Hart, who in my view is by far the most significant legal positivist, you know, I know we can have debates about Hart v. Kelson and so on, but I still find Hart immensely subtle and his theory extremely elegant and pleasing in its simplicity. Hart has what at first seemed to be a set of impressive and impressively simple solutions to these problems. So, he begins by taking the general question, what is law? And he splits it into two questions. First of all, there's a question about the type of social formation we might think of as a legal system, and the specific features which mark out legal systems as a distinct type of social formation. And here, of course, he tells us that they must have a basic rule of recognition accepted by officials, and the bulk of the population must comply with the bulk of the rules stemming from that rule of recognition. Okay, so he here captures the sort of the factual sociological aspect of law, the sense of law in which law is a social practice. And then he captures the other aspect, the normative aspect of law, the aspect of law which maybe isn't a social practice, or it isn't in anything like the same sense, when he tells us that the rule of recognition effectively calls into being a whole new sense in which rules can exist. Once you've got a rule of recognition, rules can exist in the sense of being valid, which is not the same thing as existing sociologically or being accepted or anything of that sort, but nor is it a matter of moral bindingness. Legal validity is a distinctive concept, and propositions of law, the kind of propositions that one would find in a legal treatise, are not any sort of factual assertions about social practices or human behavior or anything of that sort. When they are articulating valid rules of law, they are expressing conclusions about the applicability of the basic rule of recognition. Now, this is a very attractive, elegant solution. It blocks the infinite regress by saying that ultimately law is grounded in a rule of recognition, which is just a fact. It's just a practice of officials. And notice here that Hart is clearly, although not expressly, making the point that law is a form in which power is exercised. The reason why these officials can, by their decisions, give rise to a legal system is that they have the power. Now, that power may be the result of coercion, or it may be the result of having a population and think that the officials are immensely wise and just. However, it is the ability of those in power to get the conformity of the bulk of the population that enables them to make law. So law for Hart is a form in which power is exercised, but it's a very special form which gives rise to a particular form of normative discourse. This is a common source of confusion, because I think a lot of people have complained that Hart never really succeeds in distinguishing law from the gunman situation. But I think that is a confusion. It's not his object to fundamentally distinguish law from the gunman situation. He's saying law it can be very like the gunman situation. How like it is depends on the particular legal system you're talking about. But fundamentally, law does boil down to power. It creates the illusion of being something else because of the particular form in which power is exercised. I should perhaps mention that there's a forthcoming volume of essays about the fished walk-in debate, where I take up precisely this question with Stanley Fish, and I try to show that Hart's whole point is that law is not something fundamentally different from the government situation. It's a form in which power is exercised, and in that respect is quite similar to the government situation. Okay, so that's how he blocks the infinite regress. Ultimately, law comes down to power. That's what enables fundamental lawmaking. That's what blocks the infinite regress. The ability of legal discourse to, as it were, hover above the materials on which the law's content depends he deals with through his notion of the open texture and the penumbral case. When lawyers go, in these remarks, I'm not taking account, incidentally, of his inclusive legal positivism. That would involve me in addressing more his conception of what jurisprudence is doing. So I set that on one side for present purposes. When lawyers disagree about the law's content, in spite of all being fully aware of the cases and the statutes, they're not really disagreeing about the law. They're arguing in the penumbra. They're arguing about the indeterminacies of law and about how those indeterminacies should be resolved. And finally, law's justificatory force, he says that is technical and confined. So it's not a matter of moral justification, it's a technical and confined justification. This is one area where he's been much criticized and where Raz has argued that the judges have to be regarded as either assuming that law is morally binding or pretending that they assume that law is morally binding. Actually, I think there's a good deal that one can say in favor of Hart's position here, but I don't wish to explore that right now. What I would like to say is this, that even though this theory is, in my view, a brilliant, simple, elegant way of dealing with some core problems, it has a massive gaping flaw, which is very obvious. And the flaw is quite simply this. Derivability from a basic rule of recognition will not confer the quality of law on a rule so derived unless it is the basic rule of recognition of a legal system. And that it might not be. Suppose, for example, that we have a system where there is a basic rule of recognition accepted by officials. However, all the rules stemming from that basic rule of recognition merely confer discretionary powers to employ coercion on a variety of officials. In other words, they establish various jurisdictions for various officials who advance certain social policy objectives and can deploy coercion as they choose in the advancement of those objectives. Following Lon Fuller, I think we would say that such a system is not really a legal system. And if it is not really a legal system, then the rule of recognition of that system is not the rule of recognition of a legal system, and it therefore cannot confer the quality of law on the rules derived from the basic rule of recognition. So, a judge's duty should not be thought of as simply a duty to follow the rule of recognition and the rules stemming from that rule of recognition. A judge's duty is fundamentally a duty to the idea of law. They have a duty to advance and honor the idea of law. And those of you who know my work at all will know that I will say the idea of law is very adequately captured by Fuller's account of the 8 desiderata. Now, the 8 desiderata inform our judgment about whether particular systems are legal systems, and therefore about whether the rules stemming from their rule of recognition are themselves laws. But they can also inform our interpretation and application of individual rules. This might seem rather surprising, as the 8 requirements are often thought of as having a very formal character. However, 2 of them are especially important here. One, in Fuller's view, rules must be performable. And we should take that as meaning reasonably performable given all the other requirements on your conduct and the general state of affairs within which you're living. So when courts interpret rules, they have to interpret them in a way which fits with the general context within which those rules apply. If you're a judge deciding, company law cases, you'd better know something about how companies operate. If you're a judge deciding contract cases, you'd better know something about how markets operate. If you're a judge deciding family law cases, you'd better know something about the reality of families in your community. So performability requires a fitting of the rule to the context, and that informs the interpretation of that rule. This is an aspect of law which is interestingly strongly emphasized by Hayek, as well as by Fuller himself, especially in Fuller's essay, Reason and Fiat in Case Law. The other aspect of the 8, which is very relevant here, is intelligibility. You have to be able to understand what the rules mean. And understanding is always dependent upon our background view of the point of the utterance. So this is why in my book, in the closing pages of my book, in fact, I argue that legality and justice are intimately linked, not in the sense that they cannot clash and compete. They can clash and compete, but they can only clash and compete at the sublunar levels of attainment of those values which are actually possible for us. Each of these values can be perfectly attained only in conjunction with the other, because it's only in a context where we can say that the laws are serving justice that we can interpret the law in the light of our understanding of justice. We're then in exactly the situation we would be in if we were reading a book about justice and had to construe it in the light of our understanding of justice. Have I
Excuse me, Professor, would you be so kind and go to the conclusion, because yes, we have time.
I'm almost there. So my argument is that really Fuller's 8 precepts give us the idea of law, and they enable us to understand the scholarly, professorial, the systematic aspect of law, and they enable us to overcome the problems of open texture and the penumbra within Hart's legal theory. Okay, thanks very much. I'm sorry I went on too long.
Okay. Thank you very much, Professor, for this great presentation. According to our timetable, now we have another speech. Professor Timothy Endicott from the University of Oxford will present a paper entitled Customary Rules and Values. Professor Endicott is the author of some excellent works on the doctrine and theory of United Kingdom constitutional law and administrative law, but also works in the field of general theory of law, with particular interest in legal interpretation and relation between legal interpretation and adjudication. Professor Endicott, it is an honor that you are with us today. I give you the floor.
Thank you so much. I'm very welcome. I'm very grateful to Dr. Beata Kanarek for inviting us to the University of Szczecin. I wish we could be there in person. I'm grateful to those who have made it possible for us to talk to each other by Zoom. And I'm particularly grateful to Dr. Kanarek for sending me an article by Professor Stanisław Czapita on the concept of a conventional act and its types from 2017. Professor Czapita gives a model example of what he calls a conventional act. It's the behavior of a man who, meeting a friend in the street, tips his hat. And Professor Czapita says, this man does not so much raise and then lower his hat, although no doubt he does that, as he does something more, something else, something that no longer can be described by giving the physical and mental parameters of his behavior. Namely, he performs the act of greeting a friend. I'm going to use this story from Professor Czapita as an example of a customary rule. The tipping of your hat is a customary rule, a conventional act. If there is a customary rule that you must greet people with by tipping your hat in some circumstances, we might say there are two rules. First, that tipping your hat counts as a way of greeting a friend. And so Professor Czapita called it a rule of sense of a conventional act. And secondly, we could say there might be a conventional or customary, I'll ordinarily say customary rule, a rule of conduct that you must greet a friend. And they seem very different rules, but if we think for a moment of a customary rule that you must tip your hat to a friend when you meet, you see they come together. And that rule is both, you might say, both a rule of sense of the act of tipping a hat and also a norm requiring a certain form of behavior. I'll ordinarily talk about customary rules in that sense, but sometimes I'll be talking about what Professor Czapita called rules of sense. Now, I'm attracted to the possibility of explaining what it means to call these things rules by reference to the values that can be pursued, values for the community, and values for individuals that can be pursued by having a customary rule and that can be pursued by an individual in particular circumstances in going along with the rule. Professor Czapita said, without going into the complex question of the mode of existence of the rules of sense of conventional acts, let us only observe that they are cultural and social in nature. I think that's true. It's very important. And I think that the cultural and social nature, as he called it, of conventional acts and customary rules in general can only be well understood in terms of the values that can give reason for having customary rules and for going along with them. Now, in these very brief remarks, I'm going to set out what I find attractive about this idea, and I'm going to list 7 challenges to the idea that customary rules should be explained analytically in terms of the values that can be secured through the practice of customary rules. Challenges, it's a very loose name. Some are potential objections, and I won't claim to have met them. I believe that they can be met, but that may be because I'm an optimist, and optimism, I have to confess, is not a theoretical virtue. And I certainly want you to know that I don't propose to meet all these challenges in these few minutes. I just want to point out some of the complexities and problems that are to be met in explaining customary rules in terms of the value that they have to communities and to persons. Now, think of the rule that Professor Czapita mentions, which makes the act of tipping a hat into a greeting. Its potential value lies in a really tremendous facility that it might give to people who will benefit from having a way of greeting other people. I do agree with Professor Czapita when he suggests that the sense of language is similar to the sense of a conventional hat, like tipping a hat. And a language is an extraordinarily valuable thing. I'm just wanting to point out to you right from the start, the extraordinary value that can lie in customary rules. It gives us a facility for communication of just extraordinary complexity and worth and value. Every language is inherently valuable, or to be more precise, you might want to say it's not the language, but the social practice of using it that has value, since it would not be valuable without the actuality of its use. But if you say that, it's still valuable because of rules, customary rules of phonology, of word and sentence morphology, of semantics. Those rules are valuable. The value of a language because of its systematicity and compositionality, as they call it, and flexibility, potential for creativity, it's incomparably greater than the value of a custom of tipping your hat, but it's the same sort of value. And it makes sense of the practice of the use of a language. Now, the cultural realm, the social realm, we all know this, in this fallen world, is not a realm of good behavior, but it's a realm that we can only make sense of by understanding what might count as good behavior and understanding what is needed to live well and understanding the participation of the members of a community in a practice that is capable of being valuable because of the service it provides to participants in the practice. The normativity of a rule that you should tip your hat to greet a friend is to be understood by reference to the value of that rule, which may be very great, and is to be understood by reference to the community's endorsement or approval of the action, a sort of judgment of the community that it's to be done, which is only intelligible, that sort of judgment, in terms of the value of having a way of greeting people. Now, because customs can be bad, there are customs like rude gestures, which I will not illustrate, that facilitate abuse and degradation of one person by another. It can be wrong to go along with customs. Because of these facts about customs and for various reasons of philosophical ideology, many philosophers of law and of social theory have wanted to explain rules, customary rules, without reference to value. But I think it's impossible. And I think that, and I'll try to explain why I think it's impossible. I think it's as impossible as the attempt to explain authority without reference to value. Now, I find Joseph Raz's account of the normative force of authoritative directives, which many of you will be familiar with, very attractive. And my main suggestion today is that it's worth trying to construct a similar reason-based, value-based explanation of the normative force of customary rules. I will call it the service conception of customary rules. Many of you know the service conception of authority, as people call it, as Joseph Raz called it. There's no general norm that you or I ought to do what someone else tells us to do. But Raz thought, persons and institutions who often claim authority claim to give you reason to do this or that, and claim to give you reason to do as they say, regardless of some other considerations. And he thought, he wasn't an enthusiast for authority really, but he thought that it is conceivable that the claim to authority, to give people reasons, and to give people reasons not to act on reasons that would otherwise be perfectly sound. He thought that that claim might be legitimate. And he thought that a claim to authority can be justified if it provides a service to the persons purportedly subject to the authority by enabling them to act more successfully on reasons that apply to them. That service can be compatible with their autonomy. Their decision to treat the authority as legitimate can be an exercise of their autonomy rather than an abandonment of it. And people ought to acknowledge an authority as legitimate if they can more successfully comply with other reasons that apply to them by accepting the authority's directives as authoritatively binding than by trying to act directly on reasons that the directives purport to exclude. That's the normal justification for authority according to Raz. And it may be made out if, for example, the authority can coordinate the conduct of people who need coordination to do what they have reason to do. And legal authorities can do that by regulating traffic and so on. And then a mere fact, the say-so of an authority, of course, in a context in which their claim to tell you what to do makes sense. The fact of their say-so can have the normative force of an exclusionary reason, that is, a reason not to act on some other considerations. To obey a rule made by an authority is to treat its say-so as an exclusionary reason. Now, we can say something parallel concerning custom, and I should emphasize that I'm not actually proposing that we draw an analogy with authority. I think the explanation of authority and the explanation of custom should be parts of a unified explanation of rules, of practical rules. I am generalizing some aspects of Raz's account of authority to explain the normative force of custom. If a community treats a practice as an exclusionary reason for action, then the community has a customary rule. Just as there's no general duty to obey someone who claims authority over you, there's no general moral duty to adhere to a custom. But if your community has a customary rule, it is, rightly or wrongly, the community's practice to treat it as a matter of duty for you to adhere to it. And if you can more successfully comply with other reasons that apply to you by accepting duties imposed by customary rules as binding and exclusionary, then a mandatory customary rule is valid and binding on you. And so parallel to Raz's service conception of authority, we can have a service conception of custom. Just as you can benefit from the service that an authority provides, you can benefit from customs. In many settings, they operate to enlarge and to enrich your options, enabling you to live a better life, to do things better that are worth doing, partly by virtue of the very demands that the customary rules make on you. Tipping a hat may be a duty imposed by a customary rule. Now, of course, it might be annoying. You might have reason that you might not have, your hair might be a mess and you might not want to lift your hat. And I suppose that in some circumstances, it might even be an oppressive element in a culture. That's conceivable. But depending on circumstances, it can offer a really marvelous facility to people who will benefit from a manageable way of showing respect to other people that simplifies matters and makes it emotionally manageable to show respect through a technique that has a sort of sanction from the community. It provides a form of coordination that can be valuable to you, just as the coordination that authorities can provide can be valuable to you. Now, remember, genuinely horrible things can be done through the development and sustaining of customary rules and the practices that go with them. And a good theory of customary rules shares a common strand with a good theory of authority. For genuinely horrible things can be done by the use of authority. Now, as with authority, so with custom, in my view, the horrible things that they can be used for, the horrible things that authorities can do and communities can do, give no reason to avoid explaining customary rules by reference to value, because customs are necessary for the pursuit of some values and for the securing of some values. With both customary rules and rules made by authorities, there's a connection with morality, which is that there are values that yield moral reasons which can only be secured by going along with the custom or with the authority. So in both cases, treating a rule, a norm purportedly laid down by an authority or a rule established in custom, provides you with a potentially useful way of doing what you have reason to do. There's the service conception of customary rules. And I'm going to be reduced to only naming some of the challenges. I won't have time to go through them in depth. The first one is the first challenge to the service conception of customary rules is the challenge of distinguishing between a situation in which everyone in a community treats the practice as a reason and the situation in which they all do the same thing, everybody in the community, because they happen to have the same opinion about the underlying reasons. Joseph Raz pointed this out as an objection to HLA Hart's conception of customary rules nearly 50 years ago in his book, Practical Reason and Norms. Raz supposed that people might have a custom of going to church on Sunday and treat the fact of everybody else's behavior as a reason to go to church. Or mothers in a community might generally breastfeed their babies, but it may be that they do that not because everyone else is doing it, but because each of them thinks that it's a good thing to do. And Raz suggested that Hart's theory of customary rules was unable to explain that distinction. And wouldn't it have been helpful if Raz had explained it? And he didn't. I don't think there's any account of it in his work. I mean, think of the rule of going to church on Sunday. If that's a rule in a community, it may well be that each of the participants in the practice thinks it's the right thing to do, not because of the social practice, but for underlying reasons. And that could even be the case with tipping a hat. It's very challenging. Custom doesn't provide a service if it's just everyone doing what they see as the right thing. They're not being helped by the practice. Now, to meet this challenge, I think we might have to say that members of a community could well be treating a shared practice as a reason without even conceiving it as a reason. And that seems paradoxical. The regular form of behavior, I think, can serve members of a community, even if they don't see themselves as acting on the practice, but just think that each of them thinks that they are individually wise or virtuous. So there's a challenge for the custom, for the service conception of custom. The second and third challenges have to do with differences between custom and authority. Challenge number 2, all custom is general, whereas authorities can have legitimate normative power to impose particular norms as well as general norms. I'm not going to say very much about this. I've not thought about it enough. I think it's important. It's connected to the potential for a system of norms. And I think that authority makes systems of norms possible. Custom is not entirely unsystematic. A customary rule can confer normative powers. There can be a custom of entering into commercial agreements. With or without a legal system, there can be a custom. But although I think every legal system depends on custom, no legal system could be constructed without the conferral of normative powers to authorities. So there's a need for authority in a system of norms, I think. Challenge number 3, custom and authority are different in another way. All exercise of authority is intentional, you might say. And no custom is intentional. When I state it in that bold way, you'll immediately start thinking of potential qualifications. You see the basic idea. In my view, what people call triggering accounts of reason giving by authorities that are popular these days don't pay attention to the significance of the intention of authorities and the possibility that they might be authorized to impose obligations so that they can decide to exercise a power to impose obligations. But perhaps a triggering account of customary rules works. It might seem to make sense that the normative